Recording in progress.
Ngaba, can you manage your fellow next to you? And that frustrates you. Good morning, colleagues. We can then start. DDG, we've been waiting for you because we couldn't start. Thank you so much. We can then start with the portfolio committee meeting. We still have members that are still on their way. Honorable Shangase is on his way. I see Honorable Klute has arrived. And then let's officially welcome our new member in the portfolio committee. I know the committee membership has changed. From the EFF, we no longer have Mrs. Diale, who was part of the portfolio committee since we started in July. We are now joined by Ms. Noluchungu, who equally happens to be the chief whip of the EFF. As a new member of the portfolio committee, he's not new, he is new in the portfolio committee. So I wanted to just clarify that. Ms. Noluchungu, you are welcome to the very progressive portfolio committee, very active and energetic. We're a very beautiful blended family. We have our own issues with each other in a meeting, but outside the meeting, we have a very beautiful relation. And we do take each other to task on matters that are applicable to our oversight role. So you are welcome. On our side, members are as they are, but I will introduce all members to the team that we have. And then because of we're joined by Justice, and I've learned that we have the Minister of Justice on the virtual platform joining us. She will then equally take us through the delegation, her delegation in the meeting. So from our side as members, we have Honorable Sokopo on the far right. Next to him is Honorable Engelbrecht. Next to Honorable Engelbrecht is Mrs. Ngaba. Next to Mrs. Ngaba is Mrs. Noluchungu. And then next to her is Honorable Niehaus. And then we have at the back, Honorable Claude. Next to him is Honorable Hendricks. And next to Honorable Hendricks, we have Ubab Kasa. Other members are still on the way. Honorable Shangase is on his way, and then the committee secretary will deal with apologies that would have received. We are supported by Mrs. Soazi. Hope you wrote exams well. We've been missing you. Then we have Sis Nomandla. I don't see Bab Makalin. I think he's outside. Then we have Mr. Matabata. Then we have the committee secretary, or Mr. Mtonjin. And you have me as well. And then I will give to the DM to then lead us with the delegation that she is with, together with the National Commissioner. And then after, we'll then give it to the Minister. Thank you.
Thank you very much, Chair. Good morning to yourself and honorable members present here, and also from the delegation from Justice. I am Lindy Winchalinchali, the Deputy Minister of Correctional Services. With me is the administration and the staff from the ministry. May I please request that the National Commissioner introduce the entire team. Thank you very much, Chair.
National Commissioner Samuel.
Thank you, Honorable Chairperson and honorable members. Thank you, Deputy Minister. In our delegation, we have Mr. Numalo from Communications. We have Mr. Stephen Naidu from Remand Detention, who is the director in the branch. We have Mr. Maponya, our Chief Deputy Commissioner responsible for IT, GITO. We have Mr. Katenga, our Chief Deputy Commissioner responsible for strategic management. Next to me on the left is Ms. Ramulifu, who is the Chief Deputy Commissioner responsible for remand detention. At the far left, the back, is Ms. Stradom, who is responsible for the Office of the National Commissioner here in Cape Town. And then we have Mr. Fakute, who is responsible for parliamentary matters as a manager in the Office of the Deputy Minister. And then myself, Honorable Chairperson, my name is Mahoti Samuel Tubakale. I'm the National Commissioner for the Department of Correctional Services. Thank you, Honorable Chairperson. Thank you, dear.
I like the Samuel name, National Commissioner. Minister of Justice and Constitutional Development.
Good morning, Chair. Good morning, honorable members. Thanks, Chair, for accommodating me to join you virtually. In the House, you've got DDG Muhanaba, who is our lead person there. You've got a representative, I will say Mr. Fanyana Ndunge, who is at the Law Research Commission. He's a senior researcher there. And then you've got Zola Kandutan, who's my PLO. Good morning to DM Jalinjali and Commissioner, together with all the delegation. Thank you. And the committee support team.
Thank you so much, Minister. We now know who is in the room for us to then can be able to start with our meeting. Members, you have the draft agenda before yourselves. Can we then have those who move for the adoption so that then we can start with the business of today? Honorable Claude, Honorable Carl, you'll follow after.
Thank you, Honorable Chair. I hereby move for the adoption of the agenda.
Thank you so much, Honorable Niehaus.
Thank you, Honorable Chair. I second the adoption and moving for the adoption of the agenda.
Thank you so much, Honorable Niehaus. The agenda is fully adopted. We can then start with our meeting. Immediately we're done with the briefing from the department and also dealing with all matters that relates to DCS. We'll then excuse the both delegation from the departments. Then we'll move to our own meeting when we get to item 4 and item 5, so that we deal with minutes and including the oversight, and to equally plan properly for our oversight in Posmo on Friday. Sia, item number 2 on apologies that would have received, inclusive of the one of Minister of Justice being on the virtual platform. Thank you.
Morning to the meeting, morning to the members, to the 2 delegations from both departments. Chair, we've got quite a few apologies today. Honorable Moela is attending the G20 Social Summit. He's not going to make it. Honorable Shangase is on his way. A standing apology from Honorable James. She's busy with the ad hoc committee or since the beginning of the ad hoc committee, Chair. And we also received an apology that the Minister of Justice could not join us physically, as she has just now alluded. She has joined virtually. That's about it from my side, Chair. Thank you.
Thank you so much, Sia. Those are apologies, members. They would then be taken as noted that would have received. We'll go to the next item on the agenda, which is the briefing by the Department of Justice on measures to address the current challenges with regards to remand detainees who are awaiting trial for more than 2 years. The rollout of the Audio-Visual Remand System, and the reasons for the low success rate of Section 63A applications. So this is a briefing, a presentation that we'll get from the department, and I am informed that the presentation that you would do is a joint presentation. Because I was worried when the PLO to the minister was sending us the delegation of the Department of Justice. In their delegation list, they had Ms. Cynthia Ramulifu. I then said, but Cynthia Ramulifu is DCS, it's not justice. Now I understand why. It's so, I'm being told there is a tax team, so this is a joint presentation where DCS would have equally assisted in the presentation. So we do note and welcome that. Minister, I'll hand over to yourself and the team to lead us with the presentation. Thank you.
Thank you very much, Chair. Just a few remarks from my side. I appreciate the meeting to deal with the issues. I think the team, when they speak, they will go into the issues that relates to the amendments of the Criminal Procedure Act. I think that's a major issue that would currently actually hamper quite a lot of issues that relates to within the criminal justice system. The Act has not been reviewed for many years. And I can safely say we had thought that we'll have it ready for cabinet processing by this month, which is November. Unfortunately, there's been delays, but we still committed for this financial year to be able to complete it. There were just few chapters because it's almost overhaul of the entitled. The law reform has been working hard to ensure that quite detailed research is being done and evaluation and actually benchmarking is done so that when the Act is reviewed and the bill is before us, it's actually not challengeable and it's something that we can work with and that would respond to a number of issues that have been raised. I think that's the first issue I want to flag on. Chair, the second thing I want to speak to as the team will be talking about the work that we do. They'll present in terms of where the issues are. And just to highlight, there are roles and responsibilities where it becomes difficult for us as the department, especially myself, to be able to instruct the magistrates or the judiciary because it's not allowed. So where there are challenges, for example, in terms of decisions by the courts, it becomes difficult for ministers to go and say, you should not have taken this decision. There are mechanisms that members of public or those that are aggrieved should utilize in terms of laying a complaint. And I can say this safely, Chair, that, for example, when there's an issue about a magistrate, the Magistrate Commission does act, and we've been able to dismiss quite a number of magistrates on the basis of the investigations that would have been done and actually found and terminated where there is a need. So it's a system that works. Similarly, Judicial Service Commission works in terms of complaints against judges. We're actually starting to count. We're bringing about 2 of the judges that must be impeached within this. We think that the Parliament will be able to deal with it in the beginning of February. But JSC has concluded. Now, that tells you that it's a system that works, Chair. So that's one of the issues I'm flagging, that sometimes as minister, you'd not have sight of some of the grievances that exist around the judiciary, but also those come through. We always challenge them to the right platforms so that the right action can be taken. I thought it's important as a peer before the committee that we can be able to raise these issues. But again, as part of mechanisms of management of how things are done within the judicial system and bringing in various stakeholders. At national, you have Minister of Justice meeting with the heads of courts that is led by the Chief Justice. This is the first platform where when we have issues, we're able to flag them and take them up. And then the second one, we call it NEC. NEC is National Efficiency Committee. This then brings all departments that have a role to play within the justice system. So it's a meeting where the judiciary will raise their concerns with us as government, and we have a platform to raise our concerns with the judiciary from a national level. When you go to the province, we have what we call as well PEC, Provincial Efficiency Committee, chaired by the judge president in that province with all the stakeholders. So, for example, from my side, my provincial head of justice will sit. The expectation is that the commissioner for subs will sit, and all the provincial commissioner of correctional services will sit in those PECs across. So that's what happens, or a delegated person. And that's what all of them sit in that. And then you'd have subs, you'll have all the public works and infrastructure, because they support us in that, in infrastructure. That's a platform we have as well, where we raise issues. And then at a court level, we have a platform which we call case management. So in a court, for example, in lower courts, the magistrate who is heading that court will sit with the court manager, with representatives of all the justice family or justice system family, so your police and others that have a role to play at a court level in terms of processing. And we've been resuscitating that quite effectively, because we found that in various courts, this will be not a constant thing happening. And the reason this happens, Chair, is also to be able to manage the cases, to understand the difficulties, whether it's from correctional services as they bring the detainees to court, whether it's subs in terms of them, those that they've arrested in police station and bringing them into court, and also the Justice Department, making sure that, for example, all those, and you'll have prosecutors and you'll have as well as the interpreters, lead interpreters, so that case backlog is managed as well at that point, so that they can be fast tracking or unlocking bottlenecks where they exist. I thought it's important for me to flag this because it's not in the presentation, and flag that at times what has been my observation in the portfolio is that as government, we don't utilize these platforms of engagement with the judiciary effectively. Or sometimes you find in other platforms, representatives don't go. For example, if you look at case management, you find that the magistrate will call a case management meeting, but representative of various portfolios would not be in the meeting to raise the challenges or to raise the issues. And when we meet, because the issue of, for example, of the magistrate is delegated to the DM, and DM will meet with the regional court presidents and chief magistrates forum, where we are able to get feedback on the issues and give feedback. And this is where you'll get feedback about some of the challenges that we have. So we've been working with the colleagues to be able to address that. So I just wanted to say we do have a platform where we are able to raise the issues, where we are able to engage with the judiciary, despite the fact that, for example, Chair, we will not be able to directly go and say, magistrate so-and-so, you are supposed to actually take the following decision and actually get this detainee out of prison. We are not allowed to do that. But what we can do is generally raise issues at that platform in the impact that that has in the correctional services facilities, for example. So I thought that is important for me to flag. And thank you very much, Chair. I'll hand over to the DDG and the team to do the actual presentation so that we can go in, and we hope that it will address all the issues. We'll try to get it as detailed as possible so that it can address the issues that have been requested by the Portfolio Committee. Thank you, Chair.
Thank you so much, Minister. DDG, the baton has been passed to you.
Thank you very much, Chairperson. And I wish to greet the Chair and the members of the committee
as well as the minister and the deputy minister and senior officials, the commissioner and senior officials who are in this meeting. As Ella indicated, I am Charles Mohalaba, the DDG responsible for court administration in the Department of Justice. Chair, the legislative framework as contained in this slide, as when we had our discussions with our minister regarding the powers of the minister to remedy the challenge that has been raised by the portfolio committee. And the responsibility of the minister and the powers that the minister has is in relation to the current work that is currently undertaken, and to be more specific, the review of the Criminal Procedure Act 51 of 1977. And these amendments seek in many ways, and will deal with a greater level of detail in the body of the presentation, to respond to the matters that the committee has raised. The second issue would obviously be the coordination around the criminal justice system partners. And we have seen our collaboration and cooperation with DCS in this regard. And I must confess that between myself and DDG Ramolifo and our teams have worked very closely, despite the challenges that were there, to find one another on this matter. And we must admit that there is still a lot of improvement that is still required to respond to this question that the portfolio committee has raised. And of course, the judiciary has a key role to play in this regard, in terms of the norms and standards that were set by the judiciary, in particular the Chief Justice. And of course, we'll go to a greater level of detail to indicate what are then the norms and standards which were set by the Chief Justice on the civil as well as the criminal matters. And definitely Chapter 9 that deals with the bail provisions in this regard, including the amendment of the conditions of bail, where the prosecutor will then apply before a judicial officer or the accused to either increase or reduce the amount of bail to be determined by section, in line with section 59 or 60. And this will also include putting in place additional conditions of the bail where this is applicable, so that the person who is in custody could then be released on the motivation of either the accused person, his or her legal representative, or in this instance, the prosecutor in this regard. The issues that the minister raised really deals with the coordination of the stakeholders. In this instance, we do indicate that in the slide that there's a number of role players in this regard. SAPS is one of them. DCS, a very critical stakeholder. The Department of Justice, and those who are in the coalface of service delivery in the various courts across the country will definitely be the court, interpreters, your clerks, as well as your intermediaries. And the judiciary plays a critical role in this regard to make a determination around the applicability and enforcement of certain provisions of legislation, as would later deal with it. And of course, the NPA does play a critical role on the matters that relates to bail, as they are in the forefront of the prosecutions of alleged criminality in the various courts, which will also include the role that is being played by Legal Aid South Africa, which then plays a role in representing the indigent in this country. We shall then now turn to the norms and standards that were set by the judiciary. Chair and members, in 2014, there were norms and standards which were signed by the former Chief Justice Mogoeng, which then stipulated clearly to all the judicial officers that they need to strive to finalize matters, including outstanding judgments, as speedily as possible. And in this instance, the civil matters in the High Court, the norms and standard did provide that the matter should be finalized within 1 year from the date of issue of the summons, this being the civil matters. In the Magistrates Court, the norms and standards were specific that the matter should be finalized 9 months from the date of the issue of the summons. In as far as the finalization of the criminal cases, the norms and standards made it very clear that the matters should be finalized within 3 months as soon as every accused person pleads to the charge. And then, of course, there is a further addition to the norms and standards, which deals with matters being finalized within 6 months after the accused has pleaded to the charge. And this was done in 2014. We are in discussion with the Office of the OCJ because we have now advised that the OCJ, under the leadership of the Chief Justice, is looking into the review of the norms and standards, which was set back in 2014. And given the increase in the population and given the justice needs of the population of this country, of course, the courts have experienced large numbers of sectors of the population which will seek justice and access to the courts on a daily basis, which therefore means that the current challenges that we have in the criminal justice system, particularly in the courts, and which then affects how the administration of justice and the efficient and effectiveness of the matters that are bringing us to the committee today affect those matters. We have seen backlogs in the courts. We have seen a number of other factors which causes challenges within the criminal justice system. So we're really hoping that the Office of the Chief Justice and the heads of the courts will in due course finalize the signing and finalization of the new norms and standards. When we look at the information, working very closely with our colleagues in TCS, because we do engage on these numbers almost on a monthly basis, we have seen a reduction of about 0.44% between March 2025 and September 2025 of the remand detainees. And we have also seen that currently there is a population of about 60,381 of those currently awaiting trial. And out of those numbers, there's about 5,071, which then represents about 10% of the remand population, which is awaiting trial for over 2 years. The numbers are quite high, and we're hoping that with the implementation of the strategy by DCS and working together with all the cluster members, we should be able to see the numbers really reducing. We're quite certain, Chair, that the colleagues from TCS would have brought these numbers before the committee. But as a point of emphasis, the numbers have been segregated, the 60,381, where we have seen that the province of Gauteng is leading with about 18,282, which is closely followed by the Western Cape with about 13,569. There are challenges also in the Eastern Cape, where we have about 7,170 of those. But interestingly, we see that between 7 to 10 years and 10 to 15, there are remand detainees which are still incarcerated for various reasons, which could be better explained in terms of some of the offenses that they're facing in the various courts across the country. This is another slide where we are working very closely with our colleagues in the cluster in TCS, where we have noted that for Q1 of 2025-2026, there has been at least some 16% in terms of the applications that were lodged or referred to the various courts across the country. For July, it's about 22%, which is the number of the outcomes which were positive in terms of the bail review. But interestingly enough, in the Limpopo province and the region, there has been, towards the bottom of the slide, Chair and members, about 256 of those referrals, only 2 were successful. In July, there's been about 50 of those referrals, 0 has been successful. In August, 43 of those were done, 0 has been successful. As well as September and the Q2, where we've seen about 162 for that region and 0 have been successful. And of course, I think it really resonates to what the minister reflected on, including the kind of offenses that those who have been incarcerated would have committed at that time. And of course, the discretion then of the judicial officers when these applications are made. But certainly the picture does indicate that for this region, there could be matters that we really need to look into in a greater level of detail, working together with the cluster. And then in slide number 9, we then look at the matters that relates to the what the minister then referred to as the Provincial Efficiency Committee. And this committee chair is chaired by the just president of a specific region in the various provinces. And given the nature of the challenges and the issues that are facing us as the cluster, there has been a subcommittee that has been established to look into this matter, particularly focusing on bail of less than 1,000 rands. So the cluster is fully represented in the PECs. And further to that, there has been an action plan that has been developed as a response and as an intervention to this challenge, where the colleagues from TCS would then have to provide the list of all the remand detainees. This we must indicate, Chair, it has happened. It's an ongoing exercise that we're looking into, and also focusing on those for bail which is less than 1,000 rands. And indeed, work is currently ongoing in terms of analyzing the names of those that have been incarcerated for quite a long time, for 2 years and more, looking at their matters in a greater level of detail to understand why are they still there, what are the causes of them not being released, and if there are discussions with the stakeholders at the level of the PECs, those matters are matters that must be dealt with. And this also includes, Chair and members, the local case management committees that have been established in the various courts across the country to look into matters relating to backlog, including the review of the bail provisions and any conditions that have been attached at the first instance. We then also list the specific sections that are applicable in this regard, and to be more specific, 62F of the Criminal Procedure Act, which then adds further bail conditions on release and to be placed under supervision of a probation officer or a correctional officer. And indeed, 63(1) of the CPA, which then deals with the matters that relates to the amendment of bail conditions on reducing the amount of bail. Of course, our colleagues have been dealing extensively with the review of the continued detention of remanded detainees who have been in custody for 2 years. And this work is ongoing, given the numbers that we've seen in the previous slides, where the heads of the centers do certainly take up their responsibilities in the implementation of the legislation. In slide 10, we're just reflecting, Chair, in response to the committee's directive around the status of the Audio-Visual Remand System. We wish to indicate, Chair, that there's about 22 AVR sites in the TCS facilities, which have been linked to about 47 courts across the country. And for the month of August 2025, then these are the matters that have been processed in the various provinces utilizing the Audio-Visual Remand System. We are looking at increasing the numbers, Chair, and members, working very closely with the colleagues in TCS and the cluster in general, particularly IJS, where currently there is an amount of about 35 million that has been made available for virtual courts. And those virtual courts have already been selected. The list has been concluded in consultation with IJS as well as the judiciary across the country, in the magistrates, chief magistrates, and the regional court presidents, who then made inputs into this specific work. So our view is that what we currently have, being the 22, which are linked to the 47 courts, the amount that has been made available now will really assist us in a great deal to then respond to this challenge that the committee has actually noted. And we anticipate, Chair, that the rollout of these virtual courts, it's a matter that should be finalized by the end of the current financial year, end of March next year, 2026. We then deal with some details around on slide 11, the provincial spread of the AVR, where in Gauteng, we're looking at about 18, which are linked to about 5 DCS facilities. And we've also noted that there's about 5 of those that are not functional, and we need to attend to those ones so that they are fixed. And then in the other provinces, in slide 12, the Eastern Cape is about 6, linked to about 3 DCS facilities, and all 6 are functional, Chair. KwaZulu-Natal, there's about 9 AVR courts, which are linked to 3 facilities, and 5 are functional, and there are those that are requiring refurbishment in this regard. Limpopo, there's only 1 currently not functional. We will have to attend to this one to be fixed so that it's up and running. Mpumalanga, there's 2, and both are functional. The Western Cape, there's about 8 linked to about 4 facilities, and all are functional. And the Free State has got 2, and only 1 is functional. And we just need to attend to the waiting area for the remand detainees. Once that is addressed, we're quite certain that this matter is going to be dealt with. And then in the Northern Cape, we have about 3, and all of them are functional. And Chair, as Ella indicated, the amount of 35 million which has been made available from the IJS would really assist us a long way to then increase these numbers, so that as we install in DOJ, that discussion would have taken place, Chair, with colleagues from TCS, so that all of us work collectively and as a team to link more centers across the country. And then in slide number 13, we are just reflecting, Chair and members, the factors that really contribute to the delay in finalizing of the matters. When we engage with the judiciary, either in the regional courts, because the regional courts are the courts where serious matters are being dealt with, and your district will deal with your other matters, theft, assault, and so on. But your more serious offenses would be dealt with in the regional courts. And this is where we do have a challenge around the presence of the accused. If the police are still looking for the accused, and if they are arrested, then there are questions around the changing of legal representatives. And this could be for many reasons. Either payment has not been made, or the accused person is unhappy with the level of service being received from his own legal representative. Of course, there's a request for related documents, the delay of handing over of the case documents to the new legal representatives, and of course, the issues around lack of funds. And then there are issues that relates to the additional charges, which are then brought upon against the accused. And when there are multiple accused, it then brings a plethora of challenges, where some of the accused will then bring intercalary applications in the matter, which then delays the processing of their matters in a court. So these are some of the many reasons that we face. Some of them also include the delay in securing a date at the High Court, the loss of records that we have. I think the committee would probably be aware of some of the challenges that the department had faced, particularly in 2021, where there had been a ransom attack. Some records were found, some records were still struggling, but we're working very closely with our service providers to recover those records. Of course, the challenges around the witnesses and the availability of the witnesses to then come up front to testify in these matters. I think the last one, Chair, would then be the request by the accused for the separation of the trials. This does cause further delays in the finalization of these matters because their legal rep or the accused themselves would make the application, which then the judicial officer is then expected to consider the separation of the trial. So when such applications are made, it then delays some of the matters that we have seen being raised. And of course, we have had discussions under the leadership of the minister with the LPC, more specifically to address some of the conduct of the attorneys who agreed to a date for trial or certain applications for them to be available, and to find that on that day they've double booked on other matters. We've sharply raised it with the LPC for the LPC to address the attorneys and their members that such conduct will really not be acceptable. We have found that the conduct of some attorneys does contribute to the delays of these matters. So, Chair, I think that will be the end of my part, and Mr. Mtunge here will then take over and proceed to deal with the other matters, particularly that relates to the review and the amendment of the Criminal Procedure Act, which is extensive work that is being done by the South African Law Reform Commission. Thank you very much.
Thank you, Chair and members, and good morning to the Minister and Deputy Minister. And as the Minister has indicated, my name is Fanyana Mdumbe.
Please pull the mic towards you so that we can hear. Thank you.
Yes. My name is Fanyana Mdumbe. I am an official of the Department of Justice, and I work for the South African Law Reform Commission. As the Minister has indicated, the Law Reform Commission, in collaboration with the department, is currently reviewing the Criminal Procedure Act. As members would be aware, this is an act of apartheid extraction, which has been in existence for more than 50 years. And therefore, it is possible that some of its provisions have become obsolete and redundant, have become convoluted as a result of intermittent amendments over the years. It is possible that they may require consolidation and harmonization. It is also possible that
they are not aligned with the Constitution. But over and above that, it is possible that the provisions of the Criminal Procedure Act do not respond effectively to the challenges that are currently bedeviling the criminal justice system. So, with regard to issues relating to overcrowding in correctional facilities, the lengthy remand detention and pre-trial detention, and inability of inmates to afford bail. We are looking at these issues from a different perspective. And that perspective is, we're asking the question, does the law as it currently stands provide answers to these problems? Does it adequately regulate these matters? Can these problems be attributed to the law, to the deficiencies in the law? Or should these matters be attributed to reasons other than the application of the law? Of course, Chair, the focus currently at the Commission is on the Criminal Procedure Act, but maybe for completeness, I must just indicate that the Child Justice Act also deals with procedural issues in relation to children. I think it's very important that we mention that. So, just in terms of the law, the Constitution as it currently stands, and we deal with this aspect in slide 14. The Constitution as it currently stands contains a number of measures that are aimed at ensuring, one, that accused persons enjoy the rights that are entrenched in the Constitution, and that incarceration of accused persons is a measure of last resort. It does this by promising accused persons speedy conclusion of their trials. It gives them the right to challenge the detention. It also says that accused persons must be released if doing so would be in the interest of justice. Of course, the Criminal Procedure Act expands on these constitutional guarantees. Firstly, it grants not only the courts, but police officers and prosecutorial authorities the power to release accused persons on bail, albeit in respect of less serious offenses. Furthermore, when accused persons appear in court, the court has a duty and a responsibility to ask the accused whether he or she wishes to apply for bail, and for that application to be considered by the court. Now, it is also important to mention that when accused persons is deemed eligible for bail, but they can't afford, the Criminal Procedure Act as it currently stands requires the court to conduct an inquiry into the financial situation of the accused to determine whether the accused can pay. If the accused does not have the resources to pay for bail that has been set by the court must impose conditions other than payment of money. I think that is very important to emphasize. Whether this approach that's currently contained in the Criminal Procedure Act is used by the court, that's another issue, but the law does make provision for that. As my colleague indicated, the courts also have the power to reduce amounts of bail that have been set for accused persons. Now, over and above these provisions of the law that are intended to address overcrowding in prisons, lengthy remand detention of inmates, in particular those who would have committed trivial offenses, and to ensure that the law does not criminalize poverty. These provisions were included in the law. The law goes further than that. It also addresses unreasonable delays. My colleague referred to factors that contribute to this state of affairs. But Section 342A of the Criminal Procedure Act seeks to address these issues. It requires the court to conduct an inquiry as to the causes of unreasonable delays, to establish whether the delays have had adverse effect, not only on the accused, but also on the prosecution and the witnesses, and to make an appropriate order. These provisions are currently there. There was a reference in the previous slides to Section 63A, which section empowers the head of correctional facility to approach the court to release an accused person on bail on the basis of deplorable conditions in prison. Of course, that power is circumscribed. It can only be exercised by the head of a correctional facility in respect of an accused person who would have been granted bail, but for whatever reason cannot afford. And over and above that, the conditions in prison must be such that they are not consistent with the constitutional requirement of human dignity. You also have Section 49G of the Correctional Services Act, which section caps the amount of time remand detainees should spend in remand detention. When inmates approach the expiry of 2 years in detention, that provision requires and empowers the correctional services to approach the court and ask that, and inform the court that this person has been in prison for almost 2 years. His matter has not yet commenced, and the court has the power to then decide whether or not to release the inmate on bail or to order further detention. It is the court that makes that decision. But over and above that, there is a section in the Criminal Procedure Act, in subsection 7 of Section 342A. In terms of that provision, the National Director of Public Prosecution is required to report biannually, 15 days after the end of January and 15 days after the end of July, to the Minister of Justice. And in that report, the NDPP must indicate the numbers, the names, the cases, whether or not accused person have been released on bail, of people who have been incarcerated for less than 2 years. In the High Court for 18 months, in the Regional Court, I think it's 12 months. In the Magistrates Court, it's 6 months. The purpose of that provision is to, one, apprise the executive about the plight that's faced by indigent inmates. Secondly, to apprise Parliament about these issues. Now, On slide 16, Chair, we deal with the proposals that we have made in the discussion paper that we published in February. Now, although we are of the firm view that the law as it stands addresses the issues that the committee is dealing with: overcrowding, lengthy pretrial detention and remand detention, incarceration of indigent accused because they can't afford bail. The provisions that I've mentioned address these issues. In respect of children, perhaps one should just indicate that a child who has been incarcerated, whose bail application or proceedings have been postponed, besides the requirement that the child must be above the age of 14 and the child must have committed a serious offense, and there must be a high likelihood that if the child is convicted, that child will be imprisoned. Besides those requirements, which essentially mean that children below the age of 14 can't be incarcerated. It also requires presiding officers and judicial officers to review their decisions every 14 days. And every time a child appears before a presiding officer about the matter for which the child has been arrested and accused, that presiding officer must constantly inquire whether or not further incarceration of that child is still necessary. Now, all these provisions were meant to address these issues. But we believe, as the Commission, that there is room for improvement. And we have made quite a number of recommendations, which we hope, if they are accepted and promoted by the executive and promulgated as law by Parliament, would add to the options that are currently available. Options that are currently available to the courts, options that are currently available to accused persons who seek to be released on bail. Now, the first recommendation that we have made, and this recommendation, we've made it because one of the issues that we have unearthed is that people who do not have fixed residential addresses, people who live in areas where there are no street addresses, people who live in informal settlements, when those people are arrested for having committed crimes and they apply for bail, and police officers can't establish where they live, their bail applications are often denied, because then those people pose risk. There is high likelihood that they might not come on the date set for their trial. So the likelihood of them absconding is huge. Now, to address, among others, those issues, we have recommended that we should seriously consider amending the law to make provision for pledging property as security for bail. Now, this is an innovation that other countries have introduced, in their legislative framework. We have recommended that incarceration of accused persons be prohibited in specific offenses. And these would be offenses that are referred to as fine-only offenses, or offenses where if the accused is convicted, fine would be an alternative to imprisonment. So for offenses like that, and maybe I must emphasize, this option would only apply to less serious offenses and not serious offenses. And serious offenses are those offenses that are in Schedule 5 and 6 of the current Criminal Procedure Act. So this would not apply to murder, culpable homicide, robbery, and things like that, and GBV related offenses. So that's another amendment that we think would address some of these challenges. We've also proposed that the law should be amended to make provision for the release of an accused person or the variation of bail conditions on grounds of indigence, if it is clear to the court that the accused does not have resources. In other countries, such an accused person would be declared indigent, and on the basis of that, they'd be released on their own cognizance, not with or without sureties. That is something that we don't currently have in the legislative framework. In India, this provision, a similar provision has been in existence for quite some time. We've also recommended the introduction of mandatory and automatic review of bail decisions for adult offenders. Now, I mentioned the approach in respect of children. Children are required to be brought before the judicial officer every 14 days. We don't have a similar provision for adult offenders. So we think that introducing or even exploring that intervention would also address these issues. We also recommend that an accused person who is in custody or who has been in custody for a period of 120 days or 90 days, depending on the gravity of the offense and the nature of the offense, should be released on bail unless there are compelling reasons why they should continue to be incarcerated. It is important that we add that proviso so that we don't take away the court's discretion to determine these issues. It can be an automatic release of an accused person. The court must consider all the factors and circumstances relating to the case in question and determine whether or not. But if the provision is there in the legislative framework, then that provision will be invoked by accused persons. We've also recommended that the current section 50, subsection C and paragraph D and 342A of the current Criminal Procedure Act be amended to empower the courts to inquire whether or not, firstly, the time that the accused has spent in remand detention is reasonable. If it is not reasonable, to make a determination. So we believe that the analytical framework that is currently available should be bolstered to empower the courts to deal with these issues. And these amendments, Chair, are on pages 16, pages 17, pages 18, pages 19, we are currently, just in terms of process, we are consulting on these tentative recommendations and proposals. We are working very closely with the NPA, the Department of Correctional Services, the police, these departments are represented in the committees that we have, that the Commission has established to look into these matters. So there is work, Chair. In conclusion, there is work that is currently underway, which work is intended to strengthen the law so that the law responds to contemporary challenges facing South African society and public. The courts in general would deny bail, and it is important that we emphasize this. The courts will deny bail if the accused person, if there is likelihood that the accused person will abscond, interfere with witnesses, conceal or try to destroy evidence, or if the release of the accused will bring the administration of justice into disrepute. In those circumstances, the courts will say no. Over and above that, if insufficient information and or evidence has been put before court, then the court would have no option but to remand the accused person in custody. So we are exploring these interventions as additional options to what the law currently provides. Thank you, Chair and members.
Thank you very much, Chairperson. I think from our side, to conclude the presentation, we wish to take members to slide number 20 of the presentation. And I think as the Minister has indicated earlier, Chair, that we can't engage the judiciary on specific matters because that remains their discretion. But between myself and DDG Ramolifo, we have agreed that we shall be engaging with the judiciary. They do have meetings, the Chief Magistrates Forum, they meet once a quarter. And the regional court presidents of the regional courts meet each and every quarter. We have agreed that we need to engage with the judiciary to deal with the current situation and how then are we able to work very closely with the judiciary to look into these matters while the amendments are ongoing. The process of the amendment is still ongoing. So there should be a greater level of collaboration between ourselves because it's a serious challenge. Chair, we have established, it's a new committee, the National Case Backlog Committee with various representatives, Justice, the Police, the Legal Practice Council, DCS is there. The representatives of the judiciary are part of the National Case Backlog Committee. And these are matters that we are looking into to ensure that those matters are raised and they're finalized because the committee also involves the participation of the NPA as well. Secondly, Chair, we are of the opinion that more could be done and more should be done particularly at the level of interdepartment collaboration, and to improve and deal with the issues around the implementation of the overcrowding reduction strategy. We have expressed a view to the accounting officers in the cluster that DCS alone will not be able to implement the strategy without the involvement and participation of the other cluster departments in the implementation of the strategy. Because when we leave it to DCS, sadly the strategy and its implementation and its successes will certainly fail on these specific matters. We have to improve the integration of the cluster in terms of our systems to monitor the court outcomes and track the progress of each of these cases. And as my colleague has indicated, there is an obligation on other stakeholders. The NPA in this particular case, as Ella referred to, has a legal obligation to report on these matters. So the issues around integration therefore becomes important as we wish to resolve these issues. And of course, Chair, the issues that relate to the implementation of the process, which is now currently being undertaken by the Law Reform Commission. Very, very pertinent, and I think the Minister is driving this process now to ensure that Cabinet is apprised of these matters so that the necessary amendments are put in place, which also includes dealing more specifically with issues that relates to how do we then begin to create a justice system that is not focusing on the perpetrator, but a justice system that is victim-centric. And part of the research which has been done by the Law Reform Commission really goes to the heart of how do we begin to define the issues that relates to a victim-centric justice system. We may revert back to the committee chair to provide details around that specific work. So Chair, that would then conclude our presentation. I can confirm that we do certainly meet with DCS as it's a joint presentation, and given the numbers that we earlier presented, and we also wish to see that this level of collaboration between the two departments should actually increase so that we're able to deal with the many, many challenges that are facing the cluster. Thank you very much, Chairperson.
Thank you so much, DDG, for the presentation. Minister, do you want to wrap it up?
No, it's fine, Chair. We'll take questions and respond.
Thank you for that. And thank you for a very detailed presentation that also talks to the review or the amendment of the Criminal Procedure Act. Members, let's talk to the report, clarities, questions, advices, all of that. I know we've been eager since April to meet with the Department of Justice on these matters. So you can understand now, and you must know that get ready for the questions. You will then note all the questions that members will raise, then you will respond. There has been a norm in this portfolio committee that no question leaves unanswered, and we shall stick to that norm. All questions that members would have asked or posed or clarities that they would have sought, they shall be responded to. If there is no response, then you would indicate that particular question, we do not have a response to it, but we'll provide the portfolio committee with a detailed one that we can take. But we do not take members not being responded to. So we would want to keep at that, Minister and the team, so that you don't see it as if this is a norm that we do in the portfolio committee. Members, hands for the questions. Engel, you'll start. Mrs. Ngaba, you'll follow. Honorable Niehaus, Honorable Sokopo, I don't know how to call you. You know, I'm thinking. No, I will decide how I call you. Leave me to decide on how I want to call you. But once I've decided, I will then call you in that sequence. Honorable Noluchungu. So I'm still deciding with my thoughts on that. You'll come after Honorable Sokopo, Honorable Klute after, Honorable Shangasa, Honorable, okay, it's all members are speaking. I will do this game because of it's all members speaking. Honorable Sokopo, you'll start. Engel, you'll follow. Mrs. Ngaba, Honorable Noluchungu, Honorable Niehaus, Honorable Klute, Honorable Shangasa, Honorable Hendricks, Babgasa. Sivala ngawe ukugcina. And angiyaza angizukuthetha mina after wena ucebile because uzavala yonke into. In that sequence, members.
Thank you, Chair. Sorry, thank you, Chair. And let me take the opportunity to welcome both presentations. I pick up on the opening remarks of the Minister and the second presenter. They make this point, in fact, all two presenters, that there is difficulty from their side to really decide on how the judiciary works on their issues. And I take note of that, Chair. But in the second presentation, I sense or I could pick up that part of our challenges that we're having at correctional services, there are in law provisions that makes provisions to attend to these overcrowding issues. And if you go to the second presenter, I would not know which slide, it indicates that there is a lack of implementation of such. That would have assisted us not finding ourselves here, where either the courts are not sticking to what they have to do in terms of after 14 days considering, and I'm also before I continue with my questions, say that I'm very happy with the proposed acts that you are bringing. I think they are very progressive and they stand an opportunity to make our life easy. Be as it may, Chair. Be as it may, Chair, I just want to check what explained the continuing underutilization of Section 63A, despite overcrowding being formally acknowledged as a material and imminent threat in our facilities. That's question one. Has the GCP cluster implemented a joint standard, a SOP, for the very same section I make reference to? If yes, your presentation doesn't show any evidence of improved usage of it. I think, Chair, let me end there so that we give space to other members and I'll come back on the second round. Thank you.
Thank you. I'll chair while the chair is out. Honorable Engel, you can proceed.
Thank you very much, Chairperson, and thank you to the Department of Justice for your presentation. We always seem to tread very carefully around dishing out criticism against the judiciary, and rightly so. The independence is crucial for our democracy. However, the judiciary's independence cannot be a shield against accountability. Their decisions on sentencing, bail, and case backlogs directly cause prison overcrowding and undermine our rehabilitation mandate. If certain matters are at the discretion of the judiciary, they should use that discretion. if we look at the outcomes of that discussion, currently it's very clear that there's a very significant problem in the judiciary. We need solutions, not just the deference. The current situation is unsustainable. The reply to parliamentary question 1381 reveals that magistrates in some regions, such as GP5, work as little as 1 hour and 6 minutes per day, on average. Given that the National Backlog Committee has identified factors like frequent postponements and delays by legal representatives as key drivers of case backlogs, what specific immediate steps is your department taking in collaboration with the judiciary to enforce minimum performance standards and ensure magistrates' courts are fully utilized to clear the case backlog that is directly fueling remand detention overcrowding? The 24-25 DCS annual report shows that out of 12,567 Section 63AL bail review applications submitted to courts to alleviate overcrowding, only 2,147 were successful, a mere 17% success rate. The effectiveness of this strategy is hampered by courts. What is your department doing to ascertain why magistrates are granting so few of these applications? And what interventions are in place to ensure the judiciary gives urgent and favorable consideration to these legally mandated mechanisms designed to protect human dignity? The norms and standards for the performance of judicial functions stipulate that criminal matters in magistrates' court should be finalized within 6 months after a plea. Yet, we have over 5,000 remand detainees who have been awaiting trial for more than 2 years. What monitoring and reporting mechanisms does your department have to track adherence to these norms? And what are the consequences for judicial officers and courts that consistently fail to meet these timeframes, leading to unconstitutional detention periods? Legislative tools like 49G of the Correctional Services Act, which requires automatic court review for detainees held for 2 years, are failing with a success rate of only 3.71%. Furthermore, AVR systems are not fully functional in many courts, such as in Limpopo and the Free State. What is your department doing in concrete terms to unblock these log jams? Is there a plan to make AVR fully operational nationwide and to direct magistrates to prioritize and actively utilize these Section 49G and Section 63A applications to reduce the remand population? The South African Law Reform Commission has recommended crucial amendments to the Criminal Procedure Act, such as imposing a 90 or 120-day deadline for trial to commence. And given the clear link between delayed trials and overcrowding, what is the precise timeline for your department to introduce this amending legislation to Parliament, and will you commit to treating this as a legislative priority in the current financial year? The Constitution guarantees every accused person the right to a speedy trial. Yet the data shows a systemic failure to uphold this right, with magistrates in some regions sitting for barely an hour a day while thousands languish in remand detention. What specific measurable accountability mechanisms exist for underperforming magistrates and court presidents who oversee this dysfunctional courts? Is it not time for the judiciary to be held accountable for its role in creating perpetuating this human rights crisis? The norms and standards set by the Chief Justice are clearly treated as an optional guideline, not enforceable rules. as evidenced by the 5,071 detainees awaiting trial for over 2 years? When will your department and the judiciary acknowledge that this voluntary self-regulating approach has failed catastrophically? And what binding measures will be implemented to force courts to comply with these timeframes, including sanctions for consistent non-performance? Each remand detainee costs the state 13,000 rand per month. The judiciary's failure to process cases efficiently is directly responsible for incarcerating thousands who should not be there, burning hundreds of millions of rands annually. Does your department agree that the judiciary's operational inefficiency constitutes a profound waste of public funds? And what financial impact assessment have been done to quantify the cost of judicial delay on the fiscus? With 21,156 unsentenced inmates detained for periods from 6 months to over 10 years, is it not the case that our magistrates' courts are effectively presiding over a system of mass unlawful detention? What is your department's legal position on the potential personal liability of judicial officers who, through repeated postponements and inactivity, knowingly detain individuals for periods that clearly violate their constitutional rights? The South African Law Reform Commission's recommendations to amend the Criminal Procedure Act, which includes deadlines for trials to commence, have been languishing. Given the direct link between these legislative gaps and overcrowding, why has there been a demonstrable lack of political will from your department to table this urgent legislation? Is the comfort of the judiciary being prioritized over the constitutional right of detainees and the operational crisis in our prisons? The rollout of AVR is a case study in failure, with multiple non-functional systems due to basic issues like a lack of waiting areas. This is not complex technological challenges. It is a basic failure of project management and interdepartmental coordination. What consequences have there been for the officials responsible for this botched implementation? And will you commit to a hard public deadline to make every single AVR court fully operational? The Justice, Crime Prevention and Security Cluster is often cited as the solution, yet the remand figures continue to climb. Is it not evident that this cluster is a little more than a talk shop with no power to compel the judiciary to perform? What tangible veto-wielding authority will you seek to empower this cluster to hold the judiciary accountable for its case flow management failures? Thank you, Madam Chair.
Thank you so much, Honorable Engelbrecht, and thank you, Honorable Niehaus, for holding the fort for me. Mrs. Ngaba.
Thank you, Chairperson. I did not come with a lot of questions, but I have subsequently acquired a great deal of questions. My first question is, how many prisons have the Minister of Justice, and sir, are you the DDG? Do I have your title correct? And how many prisons has the DDG visited? So one of my first visits was to Worcester. There were men sleeping on the floor. It was so crowded, I couldn't actually get in. There was nowhere to walk. Their fumigation contract had run out. When I came out of the prison, I was scared to get into my car because I thought there's fleas and lice, and now I'm going to put this in my car. I don't think you have a full appreciation of the horror in our prisons. And we are talking to the Department of Justice. So my question to you is it justice for people to languish in those conditions when they are unsentenced? And the thing about it is that remand detention is the worst place, right? People cycle in and out. The sentenced guys look after their space because they know they have to live there. Remand is filthy. It's unconscionable. And then you have SAPs deciding to detain people in order to investigate, right? Which is part of what contributes to the very long stays pre-trial in prison. So with that context, it's not comforting for you to tell us about talk shops. I will set my hair on fire if you talk about one more thing that you are going to talk about. What we need to know is what you're going to do about all this stuff. So in the presentation, it says, if some of the provisions of the CPA were conscientiously applied and implemented, indigent accused persons eligible for bail would not be languishing in jail. Given that, as the Department of Justice, you're aware that the provisions of your legislation are not being conscientiously applied and implemented, what are you doing about it? What corrective action, disciplinary action are you taking against magistrates who fail to implement South Africa's laws? In a reply to a question of mine last month, the Minister of Justice indicated that between 0.9% and 1.1% of those who are granted bail fail to appear for their hearings. It's obviously a very marginal group that doesn't appear for bail. What steps have you taken to determine why judges and magistrates still resort to remanding suspects, even though we know that so few people actually skip out on bail when they get bail? What is a concrete step, not a talk shop? DDG, I think I heard you say that you have now agreed to engage with the judiciary. How is this being agreed now? When was that agreement? When did you guys realize that you now need to engage? And more importantly, what are the concrete outcomes that you are expecting to achieve through that engagement? You said more could and should be done. How long did it take you to realize that more could and should be done? How is this the conversation that we're having at this late stage of the game? Is the sudden realization that more could and should be done? Now, the DDG also said that the NPA has an obligation to report on these matters. My question, have they been reporting on these matters? If they are, who is doing a deep dive into those reports and determining what the implications should be taken from that report? What actions have been identified that are necessary to recommend to the NPA to fix the current state of affairs? Or is the NPA just reporting for vibes? What is actually being done with the substance of those reports if they are happening? Has there been any effort to track the performance of magistrates and judges on bail in each province, each district, each region? Has the minister investigated the training that magistrates and judges receive with regards to bail? Is the minister satisfied that magistrates and judges have proper training on the purpose and application of the provisions of the CPA on bail? Has the minister engaged with the Chief Justice and the NDPP regarding the possibility of issuing directives to judges and magistrates on how to address bail and the proper application? Has any such discussion of concrete directives being issued? Has that taken place? And then in terms, again, I'm reading from the presentation, in terms of Section 342A courts must investigate unreasonable delays which may cause prejudice to the prosecution, the accused, etc. So these Section 342A investigations, are they actually being done? Who's tracking how many have been done? And how this section is being implemented, if it's being implemented? Have you considered the feasibility of making annual prison visits by magistrates and judges a condition of employment? Because I think if they see the reality of where they are sending people, they might actually think differently. I know that there's a project to encourage this. Have you considered the feasibility of making it mandatory? And I want to echo what Honorable Engelbrecht asked on the amendments to the CPA. Can we please have timelines? When, how, etc. And then lastly, a lot of the proposals that were made on the amendments to the CPA are quite interesting. Does the department and the minister have views on those specific recommendations? Thank you.
Thank you so much, Mrs. Maba. I was looking at your hair when you said you're going to set your own hair on fire. So I had to wear my glasses to look, is there any hair that is popping out there? And I couldn't find. Please, let's make sure that she doesn't set her head on fire because there's no hair. Mamnolu.
Thank you very much, Chair, and greetings to the honorable members, the representation from Department of Correctional Services.
Mamnolu,
Go ahead. And the judiciary. Thank you also for the presentation. At the beginning of the meeting, the minister mentioned that there is a need to review the CPA. You know, it is always when there are problems, people will run to the policies. And maybe it's important that we must do introspection and see if those policies are implemented. Running to policies is not going to solve our problems. We can have the best policies, but if they're not being implemented properly, we're not going to get the results that we want to achieve. For instance, Section 63A and 43G were meant to ease the overcrowding in prisons. But the RD population keeps on rising. It has risen by 17% in the past 5 years, which shows a deeper failure in the justice system. If one looks at the success rate, for 63A, it is 17%, and for Section 45G, it is between 2 and 6%. This signals poor cooperation between the stakeholders. So it therefore means that the tools are there, they do exist, but maybe they are simply not being used effectively. For instance, how does one explain, in terms of your presentation, there are about five people that have been on waiting trial for 10 years. Am I correct? Yeah. How do you explain that? How many? Yeah. How do you explain that a person on waiting trial for 10 years? So I want to understand where is the blockage and what is driving the increase? Is it the policing, prosecution, delays, or court turnaround time? Where is the blockage? You are also mentioning the tool for tracking Section 63A and 49G cases. Does this automatically flag anyone who reaches 6 months or 2 years in detention? If so, where do these alerts go? Or are you still depending or relying on manual follow-ups? Thank you.
Thanks so much, Mamnolu. Honorable Nihas.
Thank you, Honorable Chair. And let me thank the Department of Justice and Constitutional Development, and also our own department of this committee, the Department of Correctional Services, for being here, and the presentation that we received from the Department of Justice and Constitutional Development. I'm very glad that eventually we managed to get this meeting, and that the minister, albeit virtually, is here with us today. Because, Chair, the problem that we are faced with is that correctional services is at the end of the supply line, so to speak. And when we talk about the terrible conditions of overcrowding in our prisons, it is the result of the failure of the whole justice cluster. And I would like to say specifically the very slow way in which the wheels of justice is grinding in our courts. When we are faced with a situation, Chair, where there are 21,156 unsentenced inmates who had been detained for periods ranging from 6 months up to 10 years. And I'm now not even talking about that outrageous 5 awaiting trial prisoners that have been there for over 10 years. It shows us that the Department of Justice and the courts are not functioning properly. My concern, Chair, is that we are being told that there are particular amendments of the Criminal Procedure Act of 1977. And it's fine that these amendments are finally now, hopefully before the end of the year, going to be tabled. It's sad that it took so long. This Criminal Procedure Act relates back to 1977. I'm convinced that the Act, as it stands at the moment, has provisions that are unconstitutional. It ought to have been addressed much earlier. But good, we say that we're going to address them. Amongst the provisions that are already there in order to avoid this disaster that I've just extrapolated on in terms of the large number of remand detainees, is this so-called 120-day cap for serious crimes and 90 days for less serious crimes. Chair, these particular conditions and provisions stand out only for one reason, and that is the way in which our courts find every possible way not to implement them. It is appalling to hear how many times our magistrates and judges find that they can overrule these limitations. And I want to know from the Minister of Justice and Constitutional Development what steps are going to be taken to ensure that the changes, the new provisions that we have been given in quite some detail about the Criminal Procedure Act will indeed be implemented, and that it will be possible that our courts will adhere to these conditions. Because the minister, when she started her input, emphasized the difficulty that she, as a member of the executive, is also faced with in terms of putting pressure on the judiciary. I understand that. But at the same time, we need to see the law, and we need to understand that the law will not allow the kind of leeway that has been granted to the judiciary under the current circumstances. My colleague, Mr. Engelbrecht, referred to the incredibly ridiculous lack of hard work that there are in our courts and the short hours that many of our courts sit. It's a serious problem, Chair, and it is one that has to be addressed. Chair, I also want to understand how the departments in the whole justice cluster are going to deal with the issue of the division between serious crime and less serious crime, because therein lies the rub. When the Deputy Director General of Justice says to us, we must have a victim-centered justice system, and obviously also that the Criminal Procedure Act, as it is being amended, should be victim-centered. I agree with him. But I agree with him in the following way, that when we make the distinction between serious and less serious crimes, we must be able to move much better in terms of getting those who've committed less serious crimes, and especially those who are first offenders, out of the Department of Correctional Services facilities. That's the one part of it. The second part of it, and I want to hear what the Minister and also the DG has got to say about this, is that victim-centeredness must mean that there are serious crimes that should not easily or at all get bail. I'm talking here about the violent crimes that we see in our society and gender-based violence. So I would like to see how this Criminal Procedure Act as amended will address that particular issue. Then in the context of what I've said about that the whole justice cluster must work together, I want to hear from the Department of Correctional Services. What steps have they been undertaking? And do they implement the provisions properly for those who are incarcerated for over 2 years without interruption as remand detainees? What steps have they taken to bring each case to the attention of the relevant courts in accordance with the legislative requirements, and they are there? And how successful have these endeavors been? So my question cuts two ways. The departments must tell us, are we doing our job? I'm talking about correctional services. Are we actually informing the courts about this without fail? But then we also want to hear, is the Department of Justice and Constitutional Development through our courts responding to this reality? Or are we simply faced with a situation where they wave these things out of the way? Chair, if we fail to deal with this issue, especially those who have committed minor crimes, because the issue of minor crimes also most of the time overlap with young people. If we fail to get them out of the system, we are becoming co-responsible for a whole, sadly so to say, school of criminality that plays itself out within our prisons. The quicker we can manage to get young people who have not committed serious crimes, who are first offenders, out of our jails, or even to state it stronger, keep them out of our jails, the better we will service our people, and the better we will also avoid further victims to arise. Now, let me conclude, Chair. One of the processes that has been presented to us as a way of speeding up this whole justice supply line that we go through are the AVRs. I've seen some of them functioning because we were at one of the oversight visits where we also went and looked at what is happening. It can play a significant role. And it can also help not only the Department of Correctional Services and justice to function better, but also assist our police. Because the processes that we have to go through to take awaiting trial remandees to the various courts and the dangers for escape and the cost that it has to take them there are a serious one. But my problem is that in so many instances, and Mr. Engelbrecht has also referred to it, we once again fail to implement, especially on the side of information technology. There are far too many of the AVRs that are not functioning, and there are far too many concerns that get raised also in terms of when that process is on the go, it being interrupted because of system failure. And you know as well as I do that when that happens, it has an impact on the delivering of justice. It can even be abused by someone who is charged with a serious offense if they have a lawyer that is clever enough to make use of that as a way of arguing the case of the accused. So, Chair, I conclude by saying that if we cannot deal with this issue as a full overview of the whole justice cluster, and I haven't seen, because it's not yet on the table, I haven't yet seen the amendments to the Criminal Procedure Act beyond what you have presented to us today, what you hope to do. But if the Criminal Procedure Act doesn't help to facilitate this interaction between the various departments, it will fail us. And I hope that when we finally see the Act, that it will now comply with the Constitution. Because I'm repeating what I said right at the beginning. I'm convinced that the 1977 Criminal Procedure Act, as it stands today, is not in all respects compliant with the Constitution. Thank you, Chair.
Thank you so much, Honorable Niehaus. Honorable Klute.
Thank you, Honorable Chairperson. Allow me to welcome the presentation that was presented. Going to start my questions. What is the main challenge in the coordinating roles between the South African Police Service, the NPA, Department of Correctional Services in reducing overcrowding? How is the department looking into the problem of incarcerated foreign nationals, particularly as it refers to the transfer process of undocumented foreign nationals in correctional facilities to mitigate the current overcrowding challenges? On Section 63A of the Criminal Procedure Act, in prior proceedings on 30 April 2024, and again during the budget vote 2025, the department undertook to strengthen the use of Section 63A to relieve overcrowding. Why does the current presentation not quantify the number of Section 63A referrals made in the 24, 25, and the 25, 26? While the minister furnished the committee with the breakdown per facilities, what engagements or feedback has the Department of Correctional Services received from the Department of Justice regarding the responsiveness to Section 63A applications? What operational barriers exist that prevent more frequent use of Section 63A to ease overcrowding in remand populations. The last question, Honorable Chair, if properly implemented with the necessary coordination, can Section 63A applications contribute meaningfully to reducing backlogs in correctional facilities? And I thank you.
Thank you so much, Honorable Kloete. Honorable Shangase.
Thank you, Honorable Chair. Greetings to everyone. Although Honorable Engelberg has taken all my questions, but I still have some. And then how will the Department of Correctional Services ensure active collaboration with the Department of Justice and Constitutional Development to implement legislation and reduce overcrowding in correctional centers? Two, and then what is the expected timeline for the full implementation of the visual remand detainee system, and how will its success be measured? And then the last question will be, what emergency powers will the minister use this month to fast track the release of those eligible for bail under the amount of 1,000? I thank you, Chair.
Thank you so much, Bab Shangase. At least Honorable Engelbrecht didn't cover everything, and we thank God for that. Honorable Hendricks.
Thanks, ma'am, thanks. You almost covered everything, eh? MP Engel. Let me greet Department of Justice and Constitutional Affairs and our brothers from the TCS. Welcome, guys. The first question will be the same question as our Honorable MP sitting in front of me. The Department, especially Justice and Constitutional, has you guys visited these areas where we have our detainees at? Why am I asking the question is that those places are terrible, and it is a breeding ground for young boys to become gangsters. If you ask any young boy, most gangsters in colored areas are from awaiting trial, mind you, not from sentenced prisoners. They go there, get all the necessary skills to come out. And I concur with the Honorable Nienaus. That is not a place for young men, because it can either break him or make him. And this comes from experience. I've been there many times. Some will be comments, and I'm happy for the decision by the Justice and Constitutional to form that committee. That is just a comment, it's long overdue. Why am I saying this? Few years back, I was very happy. I was very happy when the two departments merged, because in the back of my head, it was, now we are going to address this properly. Remember, the guys in TCS are operational. And you can go to many of their workers and ask, these provisions of 1977, some have been there for a while, but do some of our guys understand and know? I didn't know that there's provision made for if you don't have money for bail, that you can still come out of prison. Those are the things. Another thing I heard from the presentation is that automatically, if you don't have an address, there's no bail. I mean, surely a department like Justice and Constitutional Development, with all those learned people, I mean, there should be a mechanism, there should be a way. An address should not be a deterrent for somebody. If we say we're struggling with overcrowding, then, I mean, also in your presentation, it says that the court processes have multiple stakeholders that are interlinked. But from where I'm sitting, these stakeholders, unless you're talking about what you're still going to do, but if these stakeholders were indeed there, I think we wouldn't have had this problem, the current problem that we're sitting with. Another comment that I want to make is that I've looked at the presentation norms and standards, and I'm happy that the gentleman agreed that 2014 ago, these things are outdated. We need to be innovative. We need to think out of the box because clearly we've been struggling. The two departments are apart again. But I think it's the gentleman sitting there with the glasses that made mention that there's a decision made to work closely with DCS. And I think that will help in terms of the literature and all of these provisions, in understanding the provisions, because all in well, we have these nice provisions written in English, but we are still breeding gangsters. And this for me is very sad. It will continue if we don't. Lastly, we spoke and I saw your presentation, but there was nothing, and maybe I'm lost, there was nothing on your foreign detainees. It doesn't speak to the foreign detainees, because looking at that number, if we can firstly start with that number, we would have made a huge impact, especially talking to your foreign nationals. With that said, thanks, Chair.
Thank you so much, Honorable Hendricks. Babkasa.
Thank you, Chair. And thanks for the report by department. Although it is a disgraceful admission of failure, the government has allowed over 5,000 people to languish in jail for over 2 years without trial. And that alone is just destroying lives and betraying the constitutional right to a speedy trial. And the so-called minor decrease in the remand population, it's an insult. The entire system is broken. And from the lower court to Department of Justice. And this is a profound injustice that perpetuates a cycle of poverty and incarceration for the poor who cannot afford bail. And the state has effectively created a hidden punishment system for the innocent until they're proven guilty. Now, my question is, with over 5,000 people jailed for over 2 years without a trial, does the minister agree with me that a head department is systematically violating the constitutional right to a speedy trial? How can the minister call a 0.44% decrease in remand detainee a success when thousands remain trapped in cells? Then coming to bail review processes, and that one also is a complete farce. The success rate is pathetically low, with some regions like Limpopo having 0% success rate for the entire quarter. And this section 63A applications, it proves that it's a pointless bureaucratic exercise, not a genuine mechanism for justice. And the department is hiding legal processes that do not work. For detainees with bail under 1,000, the state inaction is a choice of keeping poor people in cages. And this is a direct attack on the poor, showing that if you cannot pay, you will stay in prison indefinitely. My other question is, why should the public have any faith in the peer review processes when its success rate is a pitiful 16% nationally and 0 in the entire region? What immediate actions will the minister take to ensure that every person who qualifies for a bail of less than 1,000 is released this week? And the rollout of the Audio-Visual Remand System. It's a scandal, wasted money, and empty promises. With only 925 sessions nationally in a month, the system is a token gesture, not a solution. And the fact that key courts in provinces like Limpopo are not even functional, it shows a total lack of commitment and oversight. The technology was meant to reduce cost and ease overcrowding, but the government has failed to implement it properly. And this is another example of a good idea being destroyed by terrible execution and lack of political will. So can the minister explain why millions are spent on AVR technology when so many sites are non-functional, like the one in Limpopo? How many years will it take to make AVR fully operational nationwide, given the current snail space? The department's own list of case backlog factors is a confession of a collapsed criminal justice system. And it blames lost files, missing witnesses, and lawyers' changes. But who is ultimately responsible for managing these issues? My answer would be the Department of Justice. And this is not a list of excuses. It's a list of the department's failure. The action plan and recommendation in this report are the same empty promises. And we had it for many years. While the problem gets worse, there's no accountability, no consequence for failure, and no urgency. Then the question is, what specific measures or what specific measurable targets has the minister set to halve the number of long-term remand detainees by the next financial year? Thank you.
Babgasa. Yeah, no. Today you really came out. I'm sitting here, I'm saying to Mr. Matabata, today we're the Portfolio Committee on Justice and Constitutional Development. I can see the Deputy Minister and the National Commission of Correctional Services that they're in the meeting, but it's not their meeting. It should be a full complement of the Department of Justice. Because of these are some of the questions that in the 6th administration, when we were part of the Portfolio Committee, when it was joined, we were dealing with the IJS, how it's supposed to ease the process within the JCPS cluster, which is non-functioning, and it starts from the police itself in terms of the case flow management, which members would have alluded to. And fully agree with Babgasa that the audio-visual courts are supposed to ease the pressure, the backlogs, reduce cost as well. But it's a total different matter. I will not even get into that. Members have asked. Perhaps my questions when they come in, I'm not sure because I had gone out and asked Honorable Niehaus to chair whilst I've stepped out. I might have missed questions that are raised by Honorable Sokopo and part of those that have been raised by Honorable Engelbrecht. Pardon me if I repeat those questions or in seeking clarity. Has the department considered decriminalizing or adopting a non-custodial penalties for low-level, poverty-driven offenses that contributes to overcrowding? And what measures are in place between the JCPS cluster to expedite processing of remand detainees in high-pressure jurisdictions? On the rollout and implementation of the AVR has been highlighted mostly by members and indicated by Bab Gasa. Might not be this week, Bab Gasa. What is the anticipated timeline for the rollout of Microsoft Teams, training of officials, and expanded configuration to address persistent functionality gaps that exist there? And in relation to the case backlog, are there any engagements taking place to address the persistent delays which are linked to loss of court records and inability to secure high court dates? And what steps have been taken by the Department of Justice, the NPA, South African Police Service, and the judiciary to institutionalize effective case flow management to shorten case cycles? And on the diversion and sentencing, are there any plans for interdepartmental efforts to expand diversion programs, non-custodial sentences, and community-based corrections as alternatives to incarceration? And how many detainees have benefited from the Section 62F supervision releases to the Section 63, subsection 1 on bail amendments? There was an inmate that we interacted with, now speaking about the 63A application process and the Section 49Gs. When we're in Mthatha, I'm not sure if the DM was with us. In Mthatha, I don't think you were with us. Were you with us? You joined us in Mthatha. When we went to the female section, you were with us. You remember there's a lady there that has 7 years. She's a remand detainee. She has 7 full years in Mthatha Correctional Facility in the remand section. So she was arrested, I think, in 2019 or 2018. Her matter has not yet started in court. Every time she goes to court, she's remanded or postponed, or changes of counsel, or those who are representing, including legal aid and including prosecution. NPA this week comes up with this, next week is legal aid, this and that. The reason I'm highlighting this is that I noted that inmate have requested the team to get the details so that I equally as the chair can follow up on her matter for 7 to 8 years. And what is worse and heartbreaking is that her co-accused are outside on bail, all of them, except her alone inside, which makes it to ponder and wonder Why are those I'm accused with in committing a crime or alleged crime are all outside, I'm alone inside? If the justice system is fair. So when we do oversight as the portfolio committee, these are some of the matters we come across and we deal with on a regular basis. We're going back again to polls on Friday. It's not an oversight per se that we normally do. It would be a follow-up because we would have done an oversight in April. But some of the damning issues that emanate or rise from that correctional facility is those that have bail less than 500 rands. A high number of the remand section in Polsmo, less than 500, not 1,000, 500 rands. There's one we're interacting with, had a bail of 300 rand. In the sixth administration, when I belonged to a joint portfolio committee, which was correctional and justice, Honorable Engelbrecht will remember when we went to Northern Cape National Commissioner in Colesbeck, we interacted with inmates who have bail of 100 rands. Minor petty crimes. So this, and you check the 100 rands for the bail that the remand detainee would have received vis-a-vis the cost to keep the detainee in a correctional facility. And the cost in terms of food, when we include medical matters, when we include the bedding, we include all things that they go through when they're incarcerated, it's more than that 100 rand. So I wanted to bring light to what members have been raising so that you don't take it as if we're now replacing the actual portfolio committee that is designated to yourselves, which is the portfolio committee on justice. But these are matters that are interlinked that the portfolio committee is faced with. And we've been hard on the department, but some of these things are not a doing of the Department of Correctional Service because of, based on the justice cluster or the IGS system, they are an end user. They receive what you bring to them and they don't choose who gets to come to their facilities. It's you who decide who comes in and who goes out, and they must keep and maintain what you bring in facilities. Hence today's meeting with the department. So I'll hand over to the minister and the team to respond to questions that members have asked. Thank you. Minister.
Thank you very much, Chair. I think there are issues that needs correctional services because there are things that we don't get involved in, and I would request that we do that. But let me allow the team first to answer, and then I'll wrap up in the response. DDG Mahalaba, if you can start in terms of that. I don't think there's anything for the law reform. I'll deal with the issues around time frames and the content. As the minister, because that would be, but deal with the issues that you can, and then I'll take the roundup, all the other issues.
Thank you very much, Chairperson, and thank you, Minister. I think, Chair, I do admit that there could be weaknesses in the current system in terms of the implementation of some of the sections that are currently contained in the current legislation. And listening to the members, it becomes clear that there's a gap that we need to deal with as a cluster. So I must agree to that, Chair. If I have visited a center, yes, that's correct. I actually have visited a correctional facility. The last one was in Mthatha, Chair, where we're engaging with the inmates there. The norms and standards, I think what we can commit as a department is to fiercely make a follow-up via our minister to the Chief Justice as to what is actually the status of the revision of the norms and standards. They are quite old, and we do agree to that. And we do take note the fact that there are some systems of the AVRs that are not actually in operation. And the commitment that we can make, Chair and members, is that we shall be addressing this matter, those that are non-functional, but also look at possibilities, given the funding that is available, to extend them to other courts and other centers. And I think that discussion, we need to have it with my colleague, the DDG from TCS. In fact, Chair, when I joined the department, within a month of having joined the department, we met with the DDG. And that's how serious I took these matters. This was my first official meeting, Chair and members, with a senior official from TCS within the cluster to deal specifically with the issues that relates to remand detainees. But what I would admit and agree is that myself and her, and with our accounting officers, we could have done better to intervene where it is so required. But this matter is on top of our agenda. The issue, Chair, around the hours, and I'm glad that the member has raised it.
Let me answer that one, DDG. Please leave it. I'll take it.
Yeah. Then there is a matter that relates to the tracking, and I think TCS does that very diligently. As soon as a matter reaches so many months and a year, 2 years, and even more, I think the colleagues are tracking that. In fact, most of the reports that we engage on a monthly basis at DEFCOM, which is a committee that I chair, the DDG and her team do provide details around, so they do track these issues. Then there was a question around the obligations of the NPA. I think, again, it's a matter that we need to improve on, the level of coordination within the cluster, because it's not only justice that plays a role, it's the cluster in its entirety, as the value chain, Chair, from the police up until where they are housed. Whether we have engaged with the NPA in terms of their legislative obligations, I've not been in a meeting where this matter was discussed with the NPA. And I'm not aware if the NTPP has provided a report in this instance. And I think it goes to just indicate, as per the observation of the members, that there are gaps with the current implementation of the current piece of legislation. So it's a matter that, as a department, we should really go back and look at the role players in terms of the law, as well as who should do what and by when and where should they be reporting to on these specific matters. Chair, we have raised the issues with the judiciary. The JP of the Free State, JP Musi, who's the chair of a committee called the Judicial Accountability Committee, has raised these issues in terms of, while the government is looking at the role that we play in the whole value chain, and to be more specific, the various departments, what then should be the role of the judiciary in this instance? Our view is that the discretion is applied by them. And I know that my colleague, DDG from TCS, has always been fighting with me on these matters, but we've been very consistent that we will assist in bringing those matters to court, as court operations, as court administration. But sadly, or unfortunately, that decision does not lie with the minister, the officials in the courts, or myself, but solely lies with the judicial officers. But what I do take is that engagement with the judiciary then becomes important going forward, given the inputs that members have raised. And then there is I think my colleague will deal with the timelines around the CPA, and I think the minister has given some instruction in this regard, and I think she will talk to it. She'll talk to those matters. We do acknowledge, Chair, the cost implications of keeping a remand detainee. I mean, we were aware of that, and I certainly agree. And these are the observations that we have also made and have discussions with the minister on the cost and the security. In this province, with the kind of challenges that we have on the gang violence and so on, it's clear that we need to continue to reduce the cost. And certainly the proposals that are being made in the CPA amendments really seeks to deal with that specific point, Chair, of wanting to limit both the risk as well as the cost that are associated with the transportation of them. And it's one thing which the minister has consistently advocated for, even when the day she joined the department, around our ability as a department to ensure that AVR is made to be available throughout the country. And the kind of investment that we need to make, including, Chair, because you can have an AVR, but if you don't have network in that court, or if DCS does not have network, then the whole system is going to collapse and fail. So in addition to then ensuring that there's resources in the facilities and in the courts, the underlying also factors have to do with our ability to provide the necessary network in the courts. So I think from our side as administration, these are matters that we do take cognizance of, and these are matters that we really have to address. The timelines, Chair, for the rollout of the Microsoft Teams virtual courts, as indicated earlier, there is about 35 million that is made available. We have identified about 35 courts which we wish then to install. Already discussions with Microsoft are at an advanced stage. We're anticipating that by the end of March, by the end of the current financial year, we should have completed the installation of such. And of course, we will be then engaging with the colleagues from TCS to look at the possibility of them connecting in those courts. I think that's how I would respond to the key issues that has been raised by the members and the chair in a summarized format. Thank you.
Thank you, DDG. Thanks, Chairperson. Let me start first by going to the Act itself. If we look at, and I literally opened, if we looked at Criminal Procedure Act, as members have been quoting 63 and 63A, there is nowhere where the Act gives any powers to Minister of Justice and Constitutional Development, nor the Department of Justice and Constitutional Development at all. And I emphasize this, members, because while the Minister of Justice is the executive authority for the National Prosecuting Authority, when you look at the NPA Act, it excludes the minister from any prosecutorial decisions, which this matter falls within the prosecutorial decisions. Again, when we look at the Constitution in terms of the judiciary is independent and does not account to the executive. That's what the Constitution says. So we are responsible for administration and financial support to the judiciary and NPA, but are not accountable, nor are we allowed to get involved in both court matters, in how a judicial decision is taken or can be reviewed. And that's why our only option is through policies, legislation, and regulations. Norms and standards in terms of courts are issued by the Chief Justice. As a minister, I get consulted on directives by the National Director of Public Prosecution, but the powers are with her. I make inputs into those directives to prosecutors. So I thought, let me start there, Chair, so that it does give us local stand on the matter. And where there are weaknesses, we can deal with from a point of a local stand of a Minister of Justice and Constitutional Development and the Department of Justice and Constitutional Development. The other point I want to raise, secondly, is perhaps, Chair, it would have been prudent that it becomes a joint committee with police and justice and constitutional development. Because I can say safely here that the three committees looks at things from a different point. The police will say to us, go talk to your judiciary. They are giving bails willy-nilly, even on the issues of petty crimes. And they will talk about repeat offenders. People who are out of bail that commit serious crime. If you look at the lady that was killed, who comes from Free State, when you go to that case, you'll find that the person who murdered her was out on bail for 500 rand. And National Prosecuting Authority had to answer, why was this person out on bail that ended up killing a young woman? So PC police will be on the case of the department, NPA, and judiciary to say, you are giving bails. Let's take the issue of which has been raised, the issue of foreign detainees. When a foreign national has committed a crime and is released on bail and they exit the Republic, to bring them back is quite a lot of efforts. So somebody can commit a crime that the bail will be 100 rand. When they go out, because it's not everybody who commits this crime that are juveniles, and we'll deal with the issue of how juveniles and correctional services can go into that area. And perhaps that's what we need to fix. Juvenile prisons that work together with social development, that they're not exposed to hardcore criminals in the main prisons. But there's realities here, honorable members, that we've got to face. And that's what I'm saying, if we had the three committees, perhaps how we look at things and that guidance to us as well, even as we work towards the review of the legislation, would be important. Now, Bushiri, for example, was out on bail and left South Africa. It's costing us a lot of money to bring him back because we've got to effect mutual legal assistance. And there's no guarantee that this person will come out. So they commit petty crimes. After that, they go and rape and leave the shores of South Africa. And the victim says to us, I need justice. And that person must come and stand trial here. So while we're thinking about how to deal with foreign nationals, because it's an issue that has come to my attention, but the issue is the thought of victims. That if a foreign national commits crime here, there are victims of that crime. When we take a decision to deport them without them standing trial and being sentenced in South Africa, is it something that victims will agree to? In many cases, they don't. Because they know that in those countries they go to, they are able to manipulate their systems and they walk away. So it's something that will need guidance from the three committees Because if you look at what is pronounced by the Committee on Justice and Constitutional Development, what is pronounced by the Committee on Police, and what is now today pronounced by the Committee are three different of correctional services, are three different issues. So I thought, let me just flag that, Chair, as we work, so that because so that we are on the same page as we work towards a review of the Criminal Procedure Act. And currently, when we look at the time frame of CPA amendments, I did say in my opening remarks that we intend to complete this within this financial year, meaning before the end of the 31st March 2026. And this work has taken long, and I agree, Honorable Member, in terms of the time. This is a 1977 Act. It's quite outdated in a number of fronts. It doesn't take into cognizance the usage of digital platforms. I mean, you've got court online being rolled out in superior courts that we want it to be rolled out in lower courts. It doesn't take those cognizance. And what has been a stopgap measure has been the norms and standards and the regulations that are issued and directives that are issued to close the gaps, especially in relation to matters that we've had court judgments on. And therefore, those becomes the basis that we are able to make a decision on and be able to include. So the review will definitely come to Parliament for members to be able to consider. I will not be able to advocate for my own personal view because I'm a member of Cabinet held individually, yes, and collectively accountable. What you will have as a view will be the view of the Cabinet once it approves that piece of legislation, which is the bill that will come to you. So I don't want to have the situation whereby either Minister of Justice has a different view against Cabinet. No, the views that will come through and in the public domain as we publish the legislation will be what is our collective view as members of Cabinet in that regard. And I agree with honorable members in the issue of when we look at the reviews of bail, and one of the issues that literally were driving us to push for the review of CPA was even around the issue of violent crimes such as GBVF, where prosecutors, because it's prescriptive in terms of law, to say, as Schedule 6, this is where you can ask for a bail and what amount of bail. This category of a schedule of a crime, Schedule 1, this is how much you can ask for a bail. And that's why, and therefore, which categories you would not ask for a bail. And that's the issue that would be able to. NPA releases its reports annually. And the annual report of NPA is presented to Parliament every October annually. And this year we have tabled NPA annual report that accounts to all the decisions that they make in terms of court. And the National Director of Public Prosecution appears before the Portfolio Committee on Justice and Constitutional Development on matters that relates to the decision, both where they've been able to have success rates in terms of conviction and categories of crimes, and whether it's, and all of them, and those, they account on those decisions. And this area of work as well is accounted for in the annual report, Chair, that Parliament receives annually in October without fail. There are no powers of minister emergency otherwise to release anyone, not a Minister of Justice. Minister of Correctional Services does have certain powers. And if you look at that as well, for example, if you look at it goes even to the commissioner. If you look at 63A, subsection 4, subsection A, section A, I hope I'm quoting it correctly. It talks to the work that can be done between consultation of the Commissioner of Correctional Services and National Director of Public Prosecution. Because these are an operational matter, it goes to that level. And because these are areas why political heads can be involved. And I must share, honorable members, the wisdom of political heads not being involved in prosecutorial, in release of accused or not accused, but even within judicial matters remains important, because you're protecting the system for not being able to be accused for political interference, nor political manipulation. Because detractors or any other political party can say, look at the person, which political party they come from, and say that person has persecuted people on the basis of political orientation. So it remains important to immune executive authorities from the point where they shouldn't be involved in certain decisions, and that remains important. Honorable members spoke about a question that was sent and the response that has been provided. If honorable member can go to that question, you'd see that there are two sections of it. The question gives you average time in terms of civil matters, family issues, but also it gives you time in terms of criminal courts performance. If you look at criminal court performance by nature, the average hours throughout are around 10 hours, 31 seconds. 31 minutes, sorry. And then you go to even and I'm going to explain why civil courts will have this. And then if you go to your other courts, such as land court and others, they will be different in terms of hours. So you look at the average hours per magistrate in terms of civil, you see it gives you about 3.44. Now, and even when you go to civil courts, I don't know if members have been to civil court. Majority of the matters in civil courts, for example, you'll have a roll call of a court roll of about 40 matters. As the judge sits there or the magistrate sits there and calls each item, you'd find that both opposing ends, they will say, we've reached agreement, we'll reach agreement. Within that particular time, I don't know if members have experienced that, have gone into a civil case, a courtroom to experience that, and they will see. And that's why it explains the court average and the times. But it doesn't mean that the magistrates immediately, they're spending an hour at court. You must remember, members, that there's preparation time, and sometimes issues members will deal with it within their chambers, especially civil matters in nature. So they will ask the parties to come and deal with the matters in terms of their chambers. So the hours that we are putting here is what is already on the floor inside a court, but not the overall responsibility of a magistrate and a court in terms of the full thing. Honorable member may ask if I've been to a correctional facility. No, I haven't. I'm still not even concluded visiting the courts themselves, which is my main function currently. So as you know, we have huge challenges in terms of justice, in terms of our courts, in terms of even expanding them. We're currently expanding sexual offences courts that I need to look at, but the deputy minister has been. So we do share responsibilities as well between myself and the deputy minister. So the deputy minister has been. I've been dealing with sorting out the issues of infrastructure in courts, rollout of and ensuring that sexual offences function effectively, but also maintenance matters are functioning effectively. That has been our key priority for this year, which I will be making a year on the 3rd of December as Minister of Justice and Constitutional Development. So there's been priority areas that I needed to focus on just to get ceilings functioning, toilets functioning in courts, working together with the Minister of Public Works and Infrastructure. And then the issue that has been raised, I think, across in terms of case management and the review. As I said at the beginning, we have platforms that we have allowed for all. And I've been monitoring this, especially at lower courts, because at higher courts, it happens effectively where there is case management. We've revived case management across the country. The committee that we are doing monitoring, DDG Mahalaba sits in that committee on my behalf with national teams to look across, receive queries on challenges that we are faced with, but also in terms of what needs to be responded to. Now, and that's why at a court level, there's also case management. I can comfortably say, members, when we look at lower courts, we do not have a lead way that is long of court case backlog in terms of new enrollments. But what we have, and which I've asked the team, is to start monitoring between the first enrollment of a case, because we have time that we have put to say a case should be in court within this time. And also in terms of the norms and standards, in terms of national, once a court, we have norms and standards that speak to, once a decision, for example, superior courts, you need to issue a judgment within this time, and that is reported. And the case management that needs more efficient, which is also difficult to do, is the time it takes for a case to move. And those are various factors, members. So what we have done from our side is to look, for example, if a case is delayed because of a prosecutor, we go pay attention to that. We get a report. We get a report and ask what has happened. And I utilize a section in the NPA Act to ask for particular reports. If there's not been justice in terms of that, you note that during the time of Omotosa judgment, I asked for a report and accountability of what has happened. It was the same case I'm mentioning of a person who was given bail. I asked in terms of a report what had happened. So that is the tool that I can use as a minister to ask for accountability, but not to interfere. Now, one of the issues we said, we should be able to start monitoring in between. But that is difficult because an accused can delay a case. For example, in cases where it's reminded, you find that this person is coming in and then tomorrow changes legal representation or be sick, submit a letter of sickness. That we find a lot in criminal cases. The delays in other cases, which I don't think are much because they are not ending up with people being arrested, in civil cases where people just delay in divorcing, which affects actually, but more importantly, because women get to be affected and end up being killed because divorce is not finalized. And the person who's opposing then delays and delays until they kill for particular reasons, whether pensions and other things. But when you look on this side of criminal issues as well, and that's why we started paying attention on the issues. And I must acknowledge one thing, members, the weaknesses in them in terms of our capacity in legal aid is there. I can't lie to members and say we've got enough capacity. We have not been able to recruit enough because of the budget cuts in terms of representation. So that sometimes you find that I was in Polokwane where I interacted with legal aid. And one of the areas where they're doing well as well. But you looked at their case backlog. They're not only working on that, moving from one case to the other, prioritizing, but they had found a system to separate the issues of RAF so that they don't deal with them. They have a specific team and then they focus on the case. It sort of alleviated some of these challenges, but it created some of the problems that we have. So members, you'd note sometimes these people that are out on 200, 500 bail and 100 are also maintenance offenders. So we'll have to look at who are these people and what crimes have they committed. Because if a person offends and does not pay maintenance and continues to ignore court orders, those people end up being arrested. And in our eyes, it will seem like it's a small offense. And therefore, that's why magistrate will issue and then they don't pay. Some of them decide because they're being vindictive. I hear horror stories. because they are vindictive to the mothers of their children. But the impact to the child when the child does not receive maintenance is that those children sometimes they need medication and they don't get it. So it's those things that we've got to look at case by case, area by area, to be able to understand how do we deal. I don't think there's a silver bullet that can respond to one area. A member says that the justice system has collapsed. Is not true, honorable member. JCPS functions effectively. But also the justice system function, it might have weaknesses. The fact that there are so many people arrested and are in courts, we have so much in terms of court roll, but also convicted criminals. It means it works. It might have weaknesses, but we can't say it doesn't work. The last point I want to raise is the issue that members are saying, perhaps we are violating the Constitution. No, it's not, honorable member. There isn't a violation of the Constitution because in terms of a fair trial, a person would be given a fair trial. In terms of being given a bail, a person will be given a bail. But the issue is that the person can't afford. And from a humanitarian point of view of some of these criminal activities or whatever that they've been, they will not be able to pay bail. And we'll have to do what? Look at legislative measures to close the gap. But honorable members, a criminal offense is a criminal offense in terms of law. And issues of children, where children are juveniles, they have not been able to make decisions properly. I agree with that. We need to build capacity to have juvenile prisons that they are rehabilitated, not integrated with the adults who then teach them how to commit hardcore crimes. I don't remember talked about how the system breeds gangsters. And that I agree with, that we've got to strengthen that area. And perhaps is one of the areas that we'll start paying attention to and eventually expand in terms of the work. But I think Commissioner will have a better understanding of it more than me, having a shorter stint in the JCPS. But the work that we've been doing as JCPS, visiting out, we've been doing even outreach. When we went to the outreach in Mthatha, Honorable Chairperson, we visited police station, we visited courts, and then we allowed our officials as the JCPS, not only correctional services, visited the correctional service in terms of one of the prisons that we have a problem with. So it shows that there's work that is being done. We need to agree and upgrade, but the criminal activities, colleagues, are becoming complex, are becoming organized, and that is for us to be able to analyze properly and get into. Thank you very much, Chair. I don't want to be like I'm preaching, but I hope I've been able to answer overall issues so that I don't become like I'm delivering another presentation, just to make sure that I answer members. But if there's a question that a member feels that I've not answered, that they feel compelled, I will definitely do so. I'm trying to be cautious of your time and allowing other colleagues to answer from correctional services.
Thank you so much, Minister. Whether you would have, you yourself and the team answered all questions that members would have asked, we'll come to that. DM, from your side.
Thank you very much, Chair. Yeah. I feel defeated, and it's a constitutional matter what the minister is really raising. To say judicial is independent. And because honorable members raised the issues of the discretion and how they give sentences or certain decision. And as correctional services, we can't be a crybaby because we're at the receiving end. But we should make the laws that work for us work for us. Honorable Nolunchung raised a matter to say, is there a need to review when there's no proper implementation? Because where we are, there's section 49G, there's section 63A. But our challenge as a department is the application submitted vis-a-vis the success rate. It's a problem. It's a serious problem, and once you are not successful, you remain within the correctional services. I think we've tried as a JCPS cluster, that committee to be functional, to sit, process matters within the provinces, but the success rate, it's really a problem. And to the minister and the department, what we're pleading for is that we're not interfering with judicial, but can they be spoken to? Because I don't think some of the matters they are declining to say that application is not successful. They've thoroughly applied themselves. Because for us as a Department of Correctional Service, it doesn't come cheap also to undergo that process. And it's legislated. So that the minister would raise these things to say, what are the consequence management thereof, of those that must take decision? The law says more than 2 years, you must start applying, and we're doing that. We package them, we do the process, we submit in every province without failure. The success rate from your quarter one, it's at 16.15%. Of 813 cases that of 25,000, 2,533 that we forwarded, only 409. Imagine the costs thereof. Also July, the month of July, 813, and you've got 182. August, 766, successful, 165. You go on and go on. So the success rate, it's what is going to help us, but we're not saying these are petty crimes. We are saying in terms of the law, they are eligible to be granted bail. Look at the conditions, review that case, and they attend court cases while they are outside. And seated here, Chair, as the minister was presenting, I was saying one department that was short of, it was the South African Police Services, because they are quick to arrest. And all cases, mostly, it's remand for further investigations. And some of these further investigations, they are sitting at this bracket of 7 to 10 years, 10 to 15 years. Where we are as a department, we reach out to the portfolio to say these meetings might assist us because we're trying at the level of the cluster. But we feel that some of the work that needs to be done is the process. Because I'm not sure in other countries, there's a detention center of the police before you come to incarceration, the corrections. But in South Africa, everybody is thrown to us. That's the problem. Because if SAPS was carrying the burden of feeding, transporting them to court, those RDs, maybe they would have felt the pinch. Because ours, in terms of the law, it's corrections, which I want to link it to saying we're breeding a youth that is gangsters and violent and so forth. Who are these people that they lend to? Those are the 10 to 15 years, because we separate them from those that are sentence offenders. Inmates, they are on, RDs, they are on their own. But you've got an inmate that has been in the system for 15 years. Every day, remand for further investigation. So it tells you we have a problem in the detective services, your IOs that are quick to arrest and not follow up on investigation and putting up a prima facie evidence before the NPA and convince the court for possible sentencing. So I think those are the things that we're still grappling with. And I want to agree today with Honorable Gas to say sometimes it's a disgrace how we work, because this chain should have been feeding. Once you have everything, you arrest, somebody appeared, prosecution, done, sentencing. It should be like that. This level of parliament and the ministers would not be sitting with saying, we are seated with a community that is awaiting trial. Some, at least they are saying they are awaiting trial, but these ones, most of them are waiting for further investigation. We're not even yet at trial stage. It's a problem. So these are the things that we would wish also South African police services to hear from us who are feeling the pinch as a department. But what we do on the RDs, because you don't put them in a formal program of rehabilitation and so forth because they are not yet sentenced, we put them on the programs of behavioral motivation and changing, because they are innocent until proven guilty by the court of law. So if we put them to programs as if they are sentenced offenders, it's something else. So those are the mitigation that we do. But I think that accountability on the failure to execute the task, yes, judiciary is independent in our country, but really they should be spoken to because they are causing a strain. Even in some of the sentences they deliver towards the department. I've raised one in the portfolio committee last week. I've raised with the minister to say some of it, the medical bills they are sending to us is quite high. And the state is not affording. So, Honorable Chair, I would allow the National Commissioner to deal with the matters he will delegate to his team. But we have a record of tracking and applying in terms of your 63A, 49, 62F, 49G, and so forth, 1 up to 5, in terms of complying with those processes. Because some of these people that are detained, sometimes they challenge us to say, you are keeping me here illegally. And the very same court will prefer another judgment that will say you are violating their rights. So we must find common ground, even if we are saying they are independent as judiciary in terms of dealing with these matters. Through you, Chair, may you allow the NC and the team to deal with those matters that deals with the areas where they operate directly as raised by honorable members towards DCS. Thank you very much.
National Commissioner?
Thank you, Honorable Chairperson and honorable members. Also the Minister of the Department of Justice and Constitutional Development, the DM Correctional Services and colleagues. Well, I will start by confirming the fact that with regards to information as to which categories we are supposed to ensure that we engage with the judiciary in terms of the Criminal Procedure Act and the Correctional Services Act. On that part, we're definitely sure that we have the information. As the Deputy Minister has indicated, we are also able to track the applications. It is in the performance agreements of each and every head of center to ensure that these applications are submitted. The remand detention branch from the Department of Correctional Services on a monthly basis without fail releases a report. So Then I would want to then also confirm that the frustration is on the side of the output. So the inputs are made into the system, but the output is a problem. And I would also want to confirm that all the regional commissioners without fail do attend the PECC meetings in the regions. They submit reports to head office, and I attend the NECC. In instances where I'm not able to attend, the Chief Deputy Commissioner responsible for remand detention is always there. My humble suggestion would be that we work on the basis of the outputs, the numbers, the real numbers. We engage, yes, as I've indicated, and that we do attend these meetings, but the issue of remand detainees and overcrowding is not the only issue that is discussed in these meetings. All other issues are discussed. So the focus on the numbers, but also to indicate that that's why we have made progress in terms of not treating overcrowding as a Department of Correctional Services matter only. It's a matter that the cluster directed by ministers and the co-chairs have taken up as a cluster issue. That's why we have a cluster strategy on overcrowding that still has to yield the expected results. There are also bilateral engagements that as the National Commissioner of Correctional Services, either through correspondence and also meeting engagements one has with specific director generals, because we categorize overcrowding. For instance, the category of foreign nationals. We have foreign nationals that have served their sentences. They simply need to be deported. Home Affairs is not doing what it's supposed to do because sometimes there's a disjuncture between what's happening at the national level and what the provinces do. We have evidence of that, where a provincial manager of Home Affairs will release a letter and say, we're no longer going to come and pick up to deport. And when you then raise the matter with the head office, they will say, we don't know anything about that. So from the side of administration, there is a lot that we need to do to ensure that there's coordination and we do our work. And of course, if we do not do our work in an integrated manner, which is the purpose of clusters, it will hit back at our ministers and deputy ministers. So I'm just saying that also on our side, we cannot present ourselves as those that do not or are not supposed to take accountability on these matters. The performance of our ministers and deputy ministers is as good as us doing our work as officials. I want to also, Honorable Chairperson, appreciate the portfolio committee's approach of bringing us together, whether we bat our heads or not, because without that, we won't be able to deal with this matter of overcrowding. In the annual performance plan of correctional services and the strategic plan, it's one of those indicators that before I even hold any regional commissioner to account, they simply say upfront that this indicator will not be able to meet because of the same considerations and factors that this portfolio committee appearance has gone over. There are specifics that the CDC remand detention, I will request Honorable Chairperson goes through. My last point would be that, especially when it comes to juveniles and the youth, it's a matter that also which the cluster is now actually even holding departments beyond the JCPS cluster to account on, is what contributions are all these departments that are either affected or their work affects the strategy. What contribution are these departments making in the implementation of the crime and violence prevention strategy? Because if we don't deal with issues there, these young people and the juveniles, in any case, end up in the criminal justice system value chain. So it's a yes, on the issues that were presented by the senior researcher on legislative review. Again, the cluster has taken an approach that says we would not be amending, for instance, or reviewing the Correctional Services Act outside other legislation that have impact or are applicable to the criminal justice system. So the Department of Home Affairs is at an advanced stage, for example, with the review of the white paper on immigration. We have made input there, and it's a matter that we are considering as a cluster. The Criminal Procedure Act, we have made inputs there. So as the Minister of Justice and Constitutional Development was mentioning earlier, the progress that is made either in legislation that is put on process by any of the departments will actually have impact on how these issues that we are raising as the Department of Correctional Services, even if we are not the ones that sponsor the legislation, but if once that legislation is seen through, the answers to our questions will also be provided. So I thought I should just make that input from a perspective of the cluster, but indicate that yes, the DM has raised the issue sharply. For us, our mandate to do corrections and rehabilitation is affected by this. We are spending more money on remand detention and those that are not supposed to be in our system, instead of spending more money in rehabilitation. That's why if you look at our program structure, our budget structure, more money is spent on incarceration as compared to rehabilitation. And the portfolio committee will always say to us, but you are not spending money in your mandate or executing your real mandate. You are spending money executing your nominal mandate. But we have to spend that money there, as the DM was able to indicate what are the cost implications, including ensuring that we uphold the required standards of safety and security. Thank you, Honorable Chairperson and honorable members. Thank you, DM.
Thank you, National Commissioner.
Good day, Honorable Chairperson. Good day, honorable members of the Portfolio Committee. I will just take you back to the Thursday where I made an undertaking that will also capture the other measures which you actually ask in terms of the addressing the improvement that we can do. Alternative sentencing in terms of section 62F, which my colleague and I were working on the issue of ensuring the MPA utilize 62F and 62 itself on the Criminal Procedure Act, so that all those 2,507 who are currently having bail for from 500 to lesser than 1,000, who are in our facility contributing to the overcrowding, MPA can utilize section 62F, just to place them under the supervision of SAPS or Supervision of Correctional Service Act. It is outside the DCS, but it can be for Justice and MPA to utilize. Our National Commissioner went also to Treasury, and he came back and directed that we must look at also the tariffs, which is the state patients tariffs that we can actually charge Department of Health on all the inmates that are within remand. That will also include the Home Affairs, all those 13,000 foreign nationals in terms of Section 34 and also 49 Migration Act, that on the daily cost, Home Affairs will then have to fund the DCS. So we are working on tariff structures for every inmate that we keep while awaiting for either judiciary. So judiciary in terms of justice will also have its cost, which are tariffs that we'll be setting for the DCS, which will bring also here to Parliament through our National Commissioner and the DM and the Minister, that can maybe assist to fast track the cost that we are losing and the expenditure on finance. That includes also the issue of South African police. Our Deputy Minister has covered it very well, that some of the contributing factors might not be the DOJ, but the South African police on the dockers, with an example of Omotose being was another contributing factor of them being within our facility. So those are the few measures that I also just wanted to share. On the modernization of the AVR, in terms of the Microsoft Teams, we definitely would like to be working as a cluster as the way it used to be before, to ensure that we drive that, but there will be a requirement for a budget for both all the sister department. My colleague already talked about the national case backlog and its subcommittees that we normally utilize for monthly. We all have different case backlog systems in terms of the totals. And there's a need that the portfolio committee, together with us, go through the same similar exercise with South African police and the MPA, so that the whole cluster can be more integrated on the modernization of the JCPS. We acknowledge the social development on the child justice. They are doing extremely well with the DOJ. We don't have a lot of children who are 14 years and above. The juvenile for 18 years and 20 years who are in the facilities, we are also trying through the National Commissioner to work with the Justice DOJ to ensure that these statistics can actually be managed. But we would like to take this opportunity also to appreciate the Portfolio Committee for this role that they are playing for us, because I'm the one that is more feeling the pressure, National Commissioner, on the overcrowding and its backlog of the cases, but the intervention on the judiciary through the Criminal Procedure Act on the amendment to give power to the Minister of Justice, so that the administration part of the officers that are working in the judiciary can be held accountable to address the fast tracking of cases, while the other process is addressing the judiciary for lower courts and divisional and regional courts. I wish to submit, Chairperson, thank you.
Thank you so much to both the Minister of Justice and the team for responding, Deputy Minister of Correctional Services, including the National Commissioner and the CDC, Ms. Ramulifu. Members, let's get first, before we come to follow-ups, if you have, are all our questions responded to? So I'll take it, all questions were responded to. Now let's get follow-ups. Mrs. Ngaba.
Thank you, Chair. I asked a number of questions about the tracking of various metrics. I asked whether they are tracking the track record of magistrates and judges on bail in the various provinces, regions, districts. I also asked about the tracking of whether Section 342A is being used. Now, the DDG conceded that actually some of these things, DCS is tracking them. And he's correct in relation to 49G and 63A. But as the National Commissioner said, we don't only need to track inputs, as in the applications that they put in. We need to know what's happening on the justice end. Who are there specific magistrates who are just doing a blanket decline? What is happening on justice side? And we don't have that information because they're not tracking it. They can't just rely on DCS to track the inputs on their side. Number two, the 342, my understanding from the DDG is that it's not being tracked. The problem is the minister came in and said, actually, the NPA is tracking these things and they report on them, and she referred to the annual report. I have the past 3 years of annual reports in front of me. They do not report on 49G, they do not report on 63A, they do not report on 342. So, two things. Number one, when the minister said, actually, the NPA does track these things in the annual report, what did she mean? Because it sounds to me like she misled the committee. Number two, if I'm looking in the wrong place, can the minister please undertake to send that data to the committee?
Thank you so much, Mrs. Ngaba. Before I give to the minister and the team to respond, the interdepartmental forums outside of the JCPS cluster, there is the national efficiency meetings. I'm not sure who sits, National Commissioner. Is it yourself or Ms. Ramulifu? It's yourself and Ms. Ramulifu. And the provincial efficiency meetings. It would be your regional commissioners who sits. Okay. Do we sit in those meetings? And if we do sit as DCS, when was the last time we attended those meetings? And have we received any feedback from the judiciary on those meetings? Or what was the feedback from judiciary on the very same meetings? Minister?
Thank you, Chair. From my side, in terms of I sit with heads of courts quarterly. I just concluded one last week with the judiciary. I only deal with the interface of the judiciary and ourselves. Issues now we are focused on the single judiciary and independent judiciary. The NEC, that's where the departments are sitting and they are represented and they raise their matters. It's only when the matters are not flagged properly at the NEC or the departments would say to me, Minister, there's an issue that has not been resolved at NEC, we are requesting. And then we make provision to invite the minister, or the Chief Justice will say to me, there's an issue that requires a particular minister, and then we invite them. Currently, the ministers that supports me from Cabinet is Minister of Finance on financial matters that we coordinate with the judiciary. It's Minister of Public Works and Infrastructure. It's Minister of Public Service and Administration that sits there. And that's the committee currently that is working on the single judiciary and independent judiciary that we're dealing with. And then others are invited on item basis. And then it will cascade. I think the commissioner will answer from their side. And then in terms of our the Correctional Service, Deputy Minister and Correctional Service Commissioner will answer for their side. And then in terms of our area of work, then in the NEC, it will be the Director General supported by the DDGs. Normally from our side, all four DDGs attend, except Osler, who is not allowed to be involved in all these things, must remain independent together with the Solicitor General. And then in the provinces, you'd have the provincial heads sitting together with other responsibility. In NEC, NDPP, as I said, NDPP stands alone. I don't represent NDPP and NPA on issues of prosecution. So they attend or head of prosecution, for example, currently is acting Advocate Mzinyatu attends, as well together with the NDPP. In the courts, it will be the court manager at that court level, together with the operational person that sits at that level in the court. So that's how we are structured across. As I said, the last meetings, mine was delayed. It's now in November. It was last week with the courts in terms of the issues. And I must be upfront, Chair, the issue of remandees has not been in our agenda. Neither has it been flagged by the NEC for it to go into the heads of courts with the Minister of Justice. So that has not been flagged for us to deal with at that level, Chair. So the escalation is on the basis that something is not working below. When it's not escalated, it means that it's being attended to. It might be slow, it might be, but they're not feeling that it needs to be at the level of Minister and Chief Justice. So it has, since I've been Minister, it has not been escalated to me, Chair. The other issue, what I want to talk about, Ms. Ngaba, Honorable Ngaba speaks about the issue of tracking. That as well, performance of magistrates and performance of judiciary, it's not within the performance of the minister. It's not allowed in law. It's our constitution. So the performance of the judiciary is the responsibility of the judiciary. That is a different arm from the executive and the state, and they take serious offense if you start involving yourself in their work. They say it's almost like parliament. When the executive wants to dictate to parliament, parliament will say we're independent, we're a separate arm. The judiciary does the same. They don't want the minister. So the powers of the minister as per the constitution in relation to that. And I think the other issue as well, where DM was saying, can the judiciary be spoken to? Yes, they can be spoken to. At the level, at the committees that are established, that's where we speak to them, at the NEC. I think maybe Commissioner Tobakali will explain what has been the response in that level where the correctional services would have raised, as it says in the PEC, if the matter has been raised, what has been the response from the judiciary. And also, I think the suggestion that the issue of correctional service subs and maybe perhaps and we'll try and monitor that, because it means NASHCOM of police from subs, Correctional Service Commissioner, NPA, NDPP must meet to deal with this matter. And it can be acting DG or it can be DG of Justice. It has to be NPA, NDPP, because the DG will not have powers to make decisions in relation to the prosecution, where the decisions needs to be made. And that's why I made this reference, members, that we've identified the weaknesses. That's why we want to amend the legislation. And I hope members will support, because I can tell you here now, the judiciary is going to fight when they hear that minister wants powers. They are going to fight tooth and nail to say this is not correct. They don't want the minister to intervene. That's why we want to have those powers within the legislation, and hoping that members will support us in that regard. Honorable member says that what I made mention about the NPA report. One of the issues that we've got to note, honorable members, the report of NPA won't talk about section of the CPA. It talks about crimes. It talks about their work in terms of bail. And what you get as you interrogate, and perhaps maybe member can join when the NPA is appearing before the Portfolio Committee on Justice as presenting, because the Justice Portfolio Committee does ask them about how many have you opposed bail, where did you apply bail, what conditions did you not. So it's classified differently. And I would be glad, member, to assist in that regard, to say, in this category, when you look at how they deal with their issues completely, and that's why some of the issues, even when we deal, Chair, you've been in this portfolio, you do understand. When you look at stats of subs and you look at our stats, sometimes it goes confusing, because stats of subs will talk about people that have been arrested. This is one case. But in NPA, each accused, even sentencing, will be counted differently. If I'm one person charged and then I have sentencing, multiple sentencing, they count it differently. So analyzing and interpreting that stats, Commissioner will tell you it's one of the fights we have in JSPS to say, can we have one identification, one stats, but because of the laws, the way they are, you find it differently. Last point, Chair, from my side. For example, and as I said, members, I do understand fully the issue of remandees and DM. But there are cases where you can't really release the people. Let's take on the people who are 7 years. I just checked on my stats. Some of them are those that are appearing before on the Senzo Miwa case, are also linked to political task team killing that currently the Madlanga and Ado committee are doing. If we are to release them, I can tell you now there'll be an uproar because these are Schedule 6 offenders. Please look at them as well. It's not only the remandees of many years that are incarcerated, that are petty crimes. I agree on petty crimes. But these other ones of long years, those people that are in, it's 8 years that trial has been running. It's a serious crime. Schedule 6. Now, if we are to write to say, and if we are to say, Minister says, I'm advocating for them, I can't do that. I can't advocate for them to be released. I would not support it. I would not support it because they are high criminals. They have the risk of repeating, offending, and worse heinous crimes. So we can make reference on some of them. The petty crimes, we can agree, colleagues. But the other ones of long years, because their trials are running, and some of them, it's them who are causing these delays, changing lawyers and everything. I'm making sense of Meiwa as a case because it's on TV for all of us. And if you count on those ones that are longer, are included in those ones. Thank you, Chair.
Thank you so much, Minister. National Commissioner? Yes.
Thank you, Honorable Chairperson. Apologies, I took a minute before I could take the mic. I was still consulting with the TN.
You were doing a debrief.
The NEC, as the Minister of Justice and Constitutional Development has indicated, it sits twice a year, and we attend those meetings. We table the issues. The PEECs, they sit every month. Our regional commissioners attend without fail. The area commissioners also attend at the magistrate level, and then the head of centers at a lower level. The outcome of our attendance is the statistics that we are presenting jointly in the meeting. That's the outcome. As I've indicated, each and every head of center must report on the applications that are made. It's in the Correctional Services Act. If they don't, they are breaking the law, basically. So they have to do it in as much as we make it a point that it's in their annual performance plan. Hence, I was saying that from an administration point of view, we really also have to work on the output. The limitation, of course, is the independence of the judiciary and other issues that the Minister of Justice and Constitutional Development was raising in terms of managing some of the heinous and high-profile crimes, especially with regards to violent crimes, crimes that are associated with gangs and all that. In some instances, we have to respond in the manner that we are responding by ensuring that some of these criminals don't go back to communities. But also at the same time, as I've indicated, from an administrative point of view, administration of justice, we have to make it a point that these processes move from through the value chain, from the point of initiation, as the Deputy Minister was indicating, from subs throughout. We have to make it a point that those processes move. Yeah, so that's the response that one can give. Our evidence of us sitting in these meetings is actually in the report that we compile out of the responses we get from the system. Thank you, Honorable Chairperson. Thank you, dear.
Thank you so much, National Commissioner. When was the last meeting the NEC that has set? When was it?
It was in May this year. The next one is coming, the second one.
And we did attend the May one.
Yes.
Okay. Thank you. So members, I think we've come to our conclusion of the meeting to release both the departments, Justice and DCS, for us to continue with our remaining agenda items. But would have to allow them to leave with few recommendations that we're going to put DDG Mulaba towards yourself as the department as led by the minister. And we do appreciate, especially the minister affording us time to and availing yourself for this meeting and take the portfolio committee through on the requested line items that we've indicated. Indeed, it took long, but it was a fruitful meeting, and we do appreciate, and some of these engagements we have given light which falls where, and in the next approach, what we should do. But it's quite worrying to hear that perhaps the JCPS cluster or the NEC, not sure where it lies, has not flagged the issue of remand detainees to be attended to, as it's a worrying contributor in correctional facilities. So in actual fact, the reason for overcrowding in correctional facilities is remand detainees. So it's a worrying factor that it's not flagged. And we have yourselves sitting in meetings where we have the Department of DCS, National Commissioner, Ms. Ramilifu as the core person that deals with this, sitting in those forums and not being able to get this flagged. Yes, we agree, DM, that perhaps subs, if we're to accommodate because of it's subs, the remand detainees fall under their ambits, perhaps we could speak a different matter on them. But we really should make sure that in these meetings when we sit, we do emphasize and echo what remand detainees in correctional facilities contribute. And I will say this because the Polsmo that we're going to on Friday is highly overcrowded by remand detainees. Modape, that we've been to, the state of Modape to be dilapidated in such an instance that it can collapse at any day. It's remand detainees. Johannesburg Correctional Center, formerly known as Sun City. It is the similar thing. So it's worrying to hear from the minister that it's not flagged from their side to attend to urgently because nothing has been raised on the matter. So we need to do better in this aspect. On the audio-visual remand, the AVR, the full rollout and functioning of the audio-visual remand will assist with addressing backlogs, save cost on transporting inmates to court, reducing risks of escapes whilst they're being transported to courts, and alleviate overcrowding in correctional facilities, whilst equally mitigating costs. Both departments should come up with measures to address identified challenges, especially to those non-functioning ARVs, to make sure that they're fully functioning. And we welcome the decision by the department as led by the minister to increase the number of AVRs from 22 to 47 courts. And whilst you are rolling out that increase of the AVR courts, would equally plead that you make use of offender labor in establishing those courts, those visual courts, to minimize cost and equally to provide skills to inmates as they serve as their programs, as part of their programs. And we'll make an example, the Goodwood Correctional Facility. It was established by inmates. The complete system, yes, there are components or things that they require technicians and so forth, you will bring it. The furniture equally inside in that Goodwood court is done by inmates. So would encourage that all that rollout be done by inmates because they are capacitated to do it. And there is workshops, I think in all regions, correctional calls them regions, provinces, where they do manufacture furnitures. So we would want to urge the Department of Justice that in that rolling out process, offender labor should be used. And on engagements with the judiciary, the proposed engagements with the judiciary will be a good start or starting point. As we have emphasized that you are going to go to the Magistrate Forum, DDG Mulaba, including CDC Ms. Ramolefu. And we hope we are going to see results, especially, or it's sitting tomorrow. Yes, we hope that we'll see results on the overcrowding reduction strategy being implemented out of those forums. And we wish you the best of luck tomorrow in that forum. As the minister would have made an indication about not entirely being able to use some platforms effectively, and one such as the CMC that she would have redirected on. So the department should make efforts to use such available platforms effectively, and would appreciate if you can give us quarterly reports on that. And this includes the update or quarterly reports on your meetings with the judiciary or the magistrate forums that you are going to tomorrow, so that there's an appraisal to the portfolio committee on the work that you are doing, especially to try and ease the pressure of overcrowding on the remand side. And we would also appreciate if you give us the quarterly updates on the LPC, being your Legal Practice Council, report outcomes on lawyers, also who or without just cause, who contributes to the overall delays of cases that honorable members would have talked to or spoken to when they were raising questions or making submissions. And whilst on it include also the quarterly report on the rolling out of the AVR and the use of Microsoft Teams, including training of officials. And this would go together with DCS. And would want to urge you to track courts which consistently loses records and therefore contributing to delays, backlogs. The committee should be appraised on this information because there's a direct bearing in forever delays and inmates being remanded because of records are being lost. So those are the submissions and recommendations we're putting. But on the foreign national matter, our standing as the Portfolio Committee on Correctional Services that we have around, I think, 28,000 foreign national inmates. And this is a stats of population of foreign national in correctional facilities. And out of those, around 14,000 are sentenced. Then the rest are remand detainees. Those who are sentenced were saying they should be in inmate exchange programs. They should be bilaterals, that they go serve their sentences in their own country of origin, not those who are still awaiting trial to be completed. Those who are already been sentenced and who equally do not have any further charges whilst they're being sentenced. They should go and serve that full sentence in their countries of origin. But those who are still remanded in our correctional facilities, they should remain there until their matter is concluded. And once concluded, and there is a sentence or a judgment that has been handed down, and that says they must be incarcerated, then let's start the process of them going to serve their sentences in their countries. That's how, as the portfolio committee, we are thinking of remedial actions in reducing overcrowding in correctional facilities. And to see this matter through, we have been urging the department on the review process of the Correctional Service Act to allow that. And once the bill comes before the portfolio committee, we will talk to that. Equally, we've made contribution to the Home Affairs on their bill on this matter. And what we're happy about is that 3 weeks back, the Portfolio Committee on Home Affairs came before Parliament to present on their bill, and they have taken our submission. That once a sentence has been handed over, theirs, it will be to deport, and they are happy to do that. So what we're asking the justice system on this matter is that the magistrate and judges must assist us, because when they hand over a sentence, they make an indication that Khomotso Ramolobeng must be incarcerated or serve his or a sentence in a particular correctional facility. And therefore, the Department of Correctional Service will not be able to deport such an inmate up until that person has concluded its sentence. That we will amend as the portfolio committee. But what we need is that the justice system should assist us to say on foreign national inmates, whilst the department is still Home Affairs, International Relations, concluding the matter of deportation, you should be incarcerated temporarily in this correctional facility. So that then, when you are sent to that correctional facility, when Home Affairs starts its process to deport you in the country of origin, it becomes easier for release. Currently, with how the Correctional Service Act, even if Home Affairs were to do it, and even the justice system, if it were to allow us to do that, will not be able to do it. The department will not be able to do it because the act prohibits that. So that's what we're asking from the justice side. Unsentenced, not those who are still remanded. Those who are remanded, we agree. Let them conclude their matters in court. And this will talk to equally agreeing with the minister on the Joint Portfolio Committee. Perhaps the Joint Portfolio Committee must integrate the justice cluster entirely. SAPS, Justice, Correctional Service, Home Affairs, because of when you speak to foreign nationals, you talk to Home Affairs. International relations, when you speak to inmate exchange programs with other countries, you must bring international relations on it so that it becomes a matter that cuts across all portfolio committees, including the IGS system, which talks to all of those. Perhaps IGS equally borrows social development on board, but in our instance, we will not want social development, but we should be having that. I will speak to my colleagues in other portfolio committees. We do have our own sessions where we talk to one another on issues that overlap or are overreaching to others, perhaps for us to be able to have that joint session where we have all ministers before that joint session and be able to talk to matters that cuts across all of us. We do agree with the minister on that, and we take that proposal, and we'll be the leading ones as correctional service to engage other portfolio committees on that end. So these are the recommendations we're putting before the Department of Justice, equally to the Department of Correctional Services, that let's try continue to minimize the overcrowding in our correctional facilities. And we do agree with the Minister of Justice that those who are remanded, even if it's longer, but it's serious crimes, they should remain. But those who are petty crimes, let's look at a different approach, perhaps a corrective supervision approach. But those who are in them for anything, whether it's Schedule 6 or whatsoever, they must then remain in custody, because of you wouldn't want to push for them to be given bail and go out and commit the very same crime, or to go against witnesses that will speak against them in court. That we do not advocate for, and then we don't push for that as the portfolio committee. But what we're saying is that those who have petty crimes, let's look at another approach, including those who are still in our juvenile. Look at an approach of how do we look at the juvenile section to be able to be rehabilitative towards them than the current setup that we're sitting with. So thank you so much once again, Minister, for availing yourself to the portfolio committee. We know your schedule is quite hectic and busy, but we do appreciate giving us the 4 to 5 hours to the portfolio committee. Even tomorrow, don't get tired when we invite you to our portfolio committee for such engagements, because out of those engagements, there are few things that we have taken as the portfolio committee that you would have given to us, yourself and the team that you have brought, that we equally will need to ponder on them. So, Minister, any parting words before we can release you?
No, thanks, Chair. I think we covered. We'll definitely take what you have summarized on and also look at how better ways we coordinate as well. Thank you very much. Really appreciate my honorable members.
Thank you, DM.
Thank you very much, Chair. And we want to appreciate this opportunity here to see government working together, because it's only us in the JCPS cluster who's going to redeem the dignity and how we work as a cluster in making sure that there is justice and people believe in our justice system. So we really appreciate, and we remain accountable to this portfolio committee, and we'll make sure that as we take these recommendations, we further deal with our challenges, because we are there in that space, and South Africans has tasked us to deal with those, and we must provide solution. With the guidance of the portfolio committee, we really appreciate the opportunity and the guidance and the advices that they've given and shared with us as a portfolio. And we would want also as a Department of Correctional Services to appreciate the Minister to make time on this busy schedule of G20. It's been a while that we wanted to meet with the Minister at this level. We don't take it lightly as correctional services, because working together and trying to resolve other matters will make our work smoother. So thank you very much, Chair, with the entire portfolio committee. Thank you.
Thank you so much, DM. Thank you once again, both Minister and the DM, for availing yourself for this meeting and really talking to the portfolio committee in some of our worrying factors, especially on the remand detainee, which are a core contributor in correctional facilities. Because of this, we've seen when we do our oversights that correctional facilities are overcrowded, not by sentenced inmates, but by remand detainees. And I think I want to also leave, before you leave, with fully agree with what the assertions that Mamnolu would have said, that we do have policies in place. The only problem is implementing them, making them a reality. So even if we can do review amendments, as long as we're not able to implement them, then it's as good as having nothing. So let's ensure that what we've set out as a guiding tool on how we must oversee certain operations of our work gets to be implemented to the T. Yes, there will be hindrances there and there, we do appreciate, but where they aren't, let's implement everything that we have in black and white. So thanks once again for coming through. Modimo le badimo ba nne le lena and ba tsamaye le lena ka nako tsotlhe. Ba le shireletse so that in the next time we meet or converge again, we're able to take such discussions further. Thank you so much. The meeting is adjourned for yourselves, the department, 5 minutes, members, so that then we conclude our business of the meeting. Thank you. Members, there is lunch. We're just gonna have a working lunch. Let's grab lunch. DDGs, normally when we have guests, we like to cater for them. Yes, so there is lunch there. DM and National Commissioner, they are aware. Okay, members, let's start. I said we're gonna have a working lunch, and I meant it. Thank you. We are going to item number 4, consideration and adoption of draft minutes. Who's populating here? So the minutes will be considered as read because we received them yesterday. I ask here to amend the agenda, colleagues, so that we don't have a backlog of minutes and so forth, so that everything can be sent out. Page 1, the minutes of the 25th July of the Portfolio Committee. And we're on virtual platform. There's nothing that you want to correct. So go to page 2. Page 3. And then the last page. Members, minutes of the 25th of July, which was a meeting we had on the virtual platform. Are we adopting the minutes? Honorable Niehaus?
Thank you, Chair. I propose that we adopt the minutes. Thanks.
Thank you. Any seconder?
Chair, I second.
Thank you, Mrs. Ngaba. We'll then move to another set of minutes. The minutes of the 9th of September. Briefing that we got on their natural death that would have occurred in Oudtshoorn and Goodwood Correctional Facility. And we're at M46 Max Building. We actually had to adjourn this meeting quicker because we're running out of time to go to the house for those who were speaking in the house or debating. The minutes would be taken as read because we would have received them in advance. So we'll then move from page 1 to check if there are any mistakes that we can pick up and correct. Page 2. Page 3. Page 4. And page 5. Hey, our closing remarks are always longer. Then page 6, which would be the last page. Honorable Hendricks, followed by Honorable Engelbrecht.
Yes, ma'am, before we adopt, I see there my surname, there's a K short, CKS. Yeah, that's the only thing I spotted. Thanks, ma'am.
Okay. Are you moving or you are clarifying the CK thing?
I was just clarifying that one.
I move for the adoption.
Okay, seconder, do you have a seconder?
I second with the corrections, Chair.
With the amendment to the surname of
Yeah.
Honorable Hendricks. So the minutes are duly adopted with the amendment. We'll move to another set of minutes. Minutes of the 16th of September. We were at the NCOP building when we received JIC's first quarter report. And equally where we were adopting our strategic plan and annual performance. And the strategic plan emanates from our strat planning when we're in Franschhoek. So the minutes will be taken as read because we received them in advance. So any corrections that you are spotting to indicate so that the team can make an amendment to them. Page 1. Then page 2. Then we move to page 3. Then page 4. Page 5. And page 6. So those are the minutes of the 16th of September when we received the first quarter report of JICS and including adopting our APP members, movers for adoption and seconder, Honorable Engelbrecht moves, seconder, Hendricks.
Second, ma'am.
Thank you. Another set of minutes. Esihleleni yonke lesikhathi singanenza ama-minutes. Normally we don't stay this long with minutes here. Okay. It's unlike us to have so many minutes. Minutes of the 17th of October, when we received, now when we're dealing with the annual report of the department, and we equally received the AG's overview on the department's annual report, including equally JIC's annual report. We were at Mark's building in the 5th floor. I think the meeting, we started there at 9. I think we adjourned at 5:30 or 6, Honorable Niehaus. 6 o'clock. I think we were left 4 members that day. So it was quite a draining and long meeting that we had. The minutes would be taken as read because we received them in advance. So we'll move to page 1. Page 2. Page 3. Page 4. Page 5. Page 6. Honorable Niehaus.
Thank you, Chair. I move that we adopt the minutes.
Thank you. Seconder, Honorable Shangase.
Meeting in minutes be adopted.
Thank you so much. The minutes of the 17th of October are fully adopted. Do we have other sets of minutes here? Yeah, there's more. We're working today. At least we're dealing with, we'll be only left with minutes of today, which we can then cover in the last week of December. The minutes of the 21st of October were the NCOP building, ELS 12A, where we received a report from a briefing by the department on issues of supply chain or their suppliers, with equally the centralization of procurement and long-term projects or contracts, and equally the review on the cost price of bread, and the adoption of our BRRR, which was meant to go to the House, which we have duly debated on it in the House. In actual fact, we're amongst the first committees to debate the BRRR. We're always ahead as Correctional Service Portfolio Committee. So, Mamnolu, you are in a good space. There's no backlog, like what we see in justice. So the minutes will be taken as read because of we have received them in advance, page 1. And we move to page 2. Page 3. Page 4. Page 5. Page 6. Sure. There are so many recommendations. Then the last page is the closing remarks. These are the minutes. Members, do we take them as a representation of what transpired in the meeting? Any movers and seconders? Honorable Hendricks,
Chair, I move so the minutes can be adopted.
seconder. Honorable Engelbrecht, seconds. The minutes of the 28th of October, sorry. I'm still in September, I don't know why. Because I'm supposed to go out. I think because of it's my birth month. Briefing by the department on their plans on the GTO Directorate, which we learned a lot about bandwidth. That's one thing I don't forget. And including remedial actions or findings by the Auditor General on that Directorate of GTO. So the meeting was on the 28th. We were in committee room 120. So the minutes will be taken as read because we have received them in advance. Then we'll move to page 1. Page 2. Page 3. Page 4. Page 5. Colleagues, those are the minutes of the 28th of October when we're dealing with the with matters. Honorable Niehaus,
I
Mrs.
move
Ngaba.
that we adopt the minutes, Chair.
Thank you, Mrs. Ngaba. You second. The meeting of the minutes of the 28th of October are duly adopted. The minutes of the 4th of November, when we received the second quarter report of JICS and the progress on the establishment of the bail fund. And that was our last meeting with the inspecting judge, Judge Cameron. So the minutes would be taken as read because we would have received them in advance. Then we'll move to page 1. Page 2. Page 3. Page 4. Page 5. Page 6. Those are the minutes on the 4th of November. Members, are they a true reflection of what transpired in the meeting? Members, the minutes? Honorable Sokopo?
I move for the adoption of the minutes.
Honorable Engelbrecht seconds. We're done with minutes here. Then we go to item 5, which is the last one. Consideration and adoption of oversight visit report in the Eastern Cape, which was on the 7th until the 11th of October. And I think we've done 5 correctional announced, 5 correctional centers and 2 unannounced visits that we've done. So the minutes will be taken as read because we would have received them in advance. Then we'll start with page 1. Yeka Mathabatha lesi sebenzisa yona laptop. Yeah, it's slow. Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Page 11. Page 12. Page 13. Page 14 on our observations and recommendations that we have put to all correctional facilities. And this also emanates from the debriefing that we would have had on Friday to talk to solutions that the department will bring on identified challenges that would have identified in all centers that would have visited. Then page 16. Page 17. Page 18. Page 19. Page 20. Page 21. We did an unannounced visit in George. And we found the facility well functioning, very clean. We need to come up with another approach of identifying unannounced. Our unannounced are turning out to be not what we are looking for. I'm worried about the choice of our unannounced. Nah, I'm not happy with myself actually here, because even in Tanzania, we did unannounced, we did not get what we thought we'll get. So we need to change our approach. So the report ends in page 22, ne Matabata? Yes. So members, especially those who were part of the oversight visit, this is the report that emanates from the 7th until the 11th of what we've done in the Eastern Cape, including the Western Cape, because the two last facilities that we visited were in the Western Cape. One was George, where we did the unannounced visit, and then Oudtshoorn, where it was an announced visit. So is this minutes of the oversight a true reflection of what transpired? Babkasa?
Sorry, Chair. I think at 10.9, paragraph 10.9, it says Mkanduli Maritzburg Correctional Center.
Yeah, a copy and paste, Matabat. Mkanduli can't belong to Maritzburg. We'll amend that. You wanted to speak to that, Babshanga, sir? Okay.
With that corrections, Chairperson, I move that the report be adopted.
Thank you. A seconder,
Second, Chair.
Honorable Hendrik seconds. The minutes of the oversight will be adopted with the amendments made to them, the report, sorry, with the amendments to it on the visit to the Eastern Cape and Western Cape, Matabata and Sia. Because the agenda says Eastern Cape, it must include Western Cape because of we did two provinces at a go. So before we could conclude our meeting, members, on Friday we are in Polsmo. Remember we did the oversight in Polsmo, was it in April? April, Honorable Niehaus? Was in April. There are recommendations that we've put to the team, the department, including the team in the correctional facility. So what we're going to do on Friday is check on those recommendations, whether they've been implemented and what is it that so far they've managed to do to change what we've seen when we went to the facility. Ordinarily, Mrs. Ngaba was supposed to go on behalf of the portfolio committee to revisit the center. At first, she was stopped by the House chairperson because of it was during constituency week. So that application could not be approved. So now we are going back because they seem to be every month something that is happening in that facility, which is wrong. And this also would lead to what would have happened or transpired 2 weeks back that I would have briefed you on the 3 officials that were stepped, with one being in ICU, but all of them are okay. With 3 inmates, when I briefed you, I made an indication of 2, was not aware there was a 3rd inmate that would have succumbed to the injuries, who equally have deceased. So ours is to go back and check whether there are systems in that facility to run that facility or management. And if they are, what are those they must take us through? And what would be the mitigation plan to try and make sure that such an incident that occurred 2 weeks or 3 weeks back does not occur again. We are learning that it's a season of gangs now. Is it crowning season, where those who need to be crowned on general statuses or whatever, because of its festive, then part of that season, you need to do something to an official. So whether the department has put systems in place to prevent such an occurrence. Lastly, so the visit mainly on that, obviously we'll also look at other areas that perhaps on the April we're not able to visit, but the kitchen will equally be our priority to go back to it. And then we'll look at other areas that we could not look into in April when we went. Apart from Polsmo, colleagues, I was alerted on Sunday in the morning. Whistleblowers, my whistleblowers are tending to be true to bringing true reflection of matters that are happening. Because once I confirm, they are confirmed. On Sunday in the morning, there's an incident that happened again in St. Albans. And rubber bullets were the center of it. So when we started the meeting, I was making the National Commissioner to listen to the video, but not show him the video, but for him to listen at the sound of rubber bullets at the far end. Because what we're getting so far, firstly, when I inquired, it was confirmed that something has happened. But what I was given was that there was a hunger strike by inmates. And they gave me a stats of the hunger strike, how many were refusing to eat, and later others then requested food and all that. But then I said that can warrant to rubber bullets being used in the process. So it is confirmed that rubber bullets have been used. So what I've requested that it must then come in writing as a form of a report. What happened, and if there are any injuries that would have occurred on the same day, and what would have been the reason for rubber bullets to be used in that instance. So I'm bringing it to yourselves if it does catch, because if I've picked up in the morning when we're driving here with Honorable Sokopo, we're listening to a report from the spokesperson of the department, Singabako Nxumalo, whom was speaking to the similar incident of St. Alban. So the media houses has catched on it so that you don't also see it or hear, but you were, so I was just alerting you that there's a whistleblower again who came forward with this matter, and then this is, I inquired and it was confirmed to be correct. So we're waiting a report on it. So once I get, I will indicate to members. So thank you so much, members, for coming through. Mamnolu, which park do you stay in? You are in Kakashia. You are in Acacia, okay. We no longer have someone who stays in Libori. It was Mrs. Dial who stayed in Libori, okay. There is transport for Friday for Pelican and Acacia, and Mrs. Ngaba here in Parliament. Your transport is here in Parliament. You'll take yourself, okay. See ya. So then they will deal with that aspect. For Friday, we will start at 9 members so that we allow those who are traveling on Friday to their constituencies to be able to take late flights to go back to your homes in Polsmo. What I was alerted on now is that the regional commissioner of the Western Cape might not be part on Friday because would have taken leave in advance and she's traveling. What I've requested to the National Commissioner is that we must be given not necessarily a report, but an undertaking. When was the leave sanctioned? If it was sanctioned immediately after we communicated our visit, therefore we will not accept that apology. But if that sanctioning of leave was done before we communicate our visit, because our visit we communicated last week. If the leave application was done after our visit, we are not accepting that apology. But if it was done before our visit was communicated, we therefore are accepting that apology. The similar apology we got from the minister for not making it on Friday. I am going to write to the minister back to say that he doesn't need to apologize anymore for oversight because he never attended any oversight and he has no interest of attending oversights. So he might as well not report because of the only person that attends is the deputy minister. Perhaps we should consider the deputy minister's apology if she's unable because she has been consistent in attending throughout. In actual fact, she has never missed an oversight. Even in KZN, she came and then later had to leave. In the Eastern Cape, she joined us later, even though she had to leave us when we go to George. But there is some willingness to work with the portfolio committee, but there is no willingness on the side of the minister, and we're not going to come to the party on that front. So I wanted to alert you members that I am going to respond. I've received it now when we started the portfolio committee meeting, that I would plead with the minister that there would be no apologies in essence to oversight. But in the portfolio committee, we are gladly to consider. But in the oversight, ayingasendwa anymore. Uyeza agezi uphuma kuye. That's the approach that I wanted to bring to the portfolio committee. So members, with that, those who are traveling, travel safe and travel back. Then we meet on Friday. You wanted to say something, Mamnolu?
Yes, thank you very much, Chair. Please be advised that Fridays I have a standing commitment. So I will attend, but I request that I be allowed to leave at 1:30, if that is okay.
No problems. With those, kindly liaise with the committee secretary for any arrangements and so forth. Colleagues, let's not deal with itineraries. There is the office of the committee secretary that deals with itineraries and so forth. So members do travel safe and travel well. I also have an ad hoc committee that is sitting on Friday. So I'm going to jiggle that with the oversight on Friday. So travel safe and make sure that we converge again on Friday. Badimo le Modimo ba tsamaele lena, ba le etelele pele ka nako tsotlhe. The meeting stands adjourned.
Recording stopped.